সভার মধ্যে বসে বিজেপি নেতা কর্মীদেরকে হুমকি দিচ্ছিল এবং সেই কারণে পুলিশ তার ভবন চেরাপ করে ঘর থেকে গ্রেফতার করে এবং এই নিয়ে আসা হচ্ছে ডায়মন্ড হারবার থানায়। এই মুহূর্তে তাদেরকে জিজ্ঞাসাবাদ চালানো হচ্ছে। ধন্যবাদ। No. Hello.
Otherwise, you will have no right of audience. For the reasons assigned in our judgment, we have allowed the appeals.
Obliged.
By the order of the division bench of the High Court.
Very well.
Why you came?
Obliged.
Huh?
Only for now.
No, this is not unfair.
Could have joined
Virtually.
22nd. Yes, next. Who appears in 802? Anyone in 802? Pass over.
May I please, my lord, 803, my lord, March of
29th May. It's coming up on 29th May.
My lords will kindly pass an
Not to
order
be
not to
deleted.
delete. So grateful,
Next.
my lords, deeply grateful.
804 coming up on 20th May.
My lord, it's already listed on 20th May, my
Yes.
lord. I'm so grateful. So grateful.
805. 805 no date. Anyone in 805?
Yes, your lordship. 805.
You are appearing?
Yes.
Very well. August. Now column.
Your lordship, the month of July it may be.
No, month
because
of
it's a-
July we have only 2 weeks. 1 week would be entirely miscellaneous. Wait till August, sir.
in first week of August. It may please your
Be there
lordship.
in August. 802.
Okay.
802 में
Mute me, na?
देखो कैसे मिस्टेक करता है यहाँ पे लास्ट ऑर्डर इज 14th of September 2020 ठीक है इसके बाद कोई जिक्र नहीं है
That even after 2 years,
हाँ.
6.
even on second call although in the mentioning slip it is stated that the bail application filed on 20th August 2025 has not been listed till date. We find from the ROP dated 9 September 2025 that the application for bail into bracket IN number 201945/2025 was rejected. In such view of the matter, no order is passed on the mentioning slip. Item 1.
There's no reply.
May it please, my lord. In item 1, my lords, I appear for the state. We filed a counter on Saturday, my lords, and unfortunately it's not on record. I really apologize. Would my lords have it in 2 days' time? Then I'd get it on record.
Who's appearing for the state?
He's filed,
I appear for the state, my lords. Can my lords hear me?
but
Okay.
the reply has been filed on Saturday.
That's not there.
Filed on Saturday, my lords. We called them, but the registry people had left.
Very well.
So it's not on record. I'm very sorry.
Counsel for the state of Bihar submits that reply affidavit has been filed on Saturday last. Stop para. Registry is directed to tag the reply affidavit with the records released on Monday next.
Monday next. I'm so grateful, my lords. I'm very sorry. I'm grateful.
Item 2, I'm for the petitioner.
Who appears for state of Gujarat?
My lords, I appear for the state of Gujarat.
Where is your counter, madam?
My lords, it has not been filed yet, but the petitioner has not joined the investigation despite
You must
even
say that or
sending
no.
notice.
You must say that or no that he has not joined investigation.
Yes, my lords, if you
file
may
your
grant
counter.
us
File your
a
counter.
couple of
Madam Counsel appears on behalf of the state of Gujarat and prays for extension of time to file counter affidavit. Sub para.
my
Declared
lords,
granted.
please
Sub para.
instruct him to join the investigation meanwhile because he is not
With the
responding to our
allowed.
notice.
Stop. Para. Let counter affidavit be filed by 20th July, 20 July. To be filed by 27th July. Delist the special petition in the first week of August. On the same terms as indicated earlier in the order dated 23rd March 2026, interim protection shall continue till the next date of hearing.
Grateful, my lords.
Grateful.
Item 3, who is for the petitioner?
Yes, Lordship, I am appearing for the petitioner, Lordship.
Yes, sir. What is this matter?
Four died.
Yeah, Lordship, this is matter regarding a regular bail, Lordship.
We have one question.
Yes, Lordship.
Initially, it was under 307, right?
Yes, Lordship.
4 people died.
Thereafter, 302 was added.
Yes, Lordship.
When was 302 added?
After
After
At
the
the
High Court's
time of
order or before the High Court's order?
before High Court's order, Lordship.
So why did you not disclose it to the High Court even?
Lordship, I have
High
disclosed
Court
it.
has rejected on the ground
Lord.
that the offense is under 307. You
No,
don't
Lordship.
disclose.
No, Lordship. It is mentioned in our order. I have mentioned it. This is under 302, Lordship. Kindly see
You
para
mentioned it.
1, Lordship.
Okay.
Yes,
How
Lordship.
many people have died?
Lordship, 4 people died.
4 people have died.
Yes, Lordship.
Trial is in progress.
Trial is in progress, Lordship. There are 75 witnesses. Out of only 5 witnesses have been examined till date.
You're responsible for the death of 4 people.
No, Lordship. I am not. I am not involved directly, Lordship. I have been implicated by on the basis of memorandum, Lordship.
He's been
There is a enmity between the parties.
Who
So they
appears for the
named-
state?
I'm there, Your Lordship. I'm appearing for the state, Your Lordship. And
What?
it is true that his name was not there in FIR initially, but subsequently in the memorandums recorded under 27, all the people mentioned his name, Your Lordship, and thereafter he was incorporated. And he participated. He participated. He played an active role in the entire incident, and accordingly he was charged, Your Lordship.
There are
Only
11 accused.
11 accused, Your Lordship.
11 accused.
In total,
One on
32, Your
bail.
Lordship. Total 32. 32
Total?
accused are.
How many
32 accused.
32.
32, Your Lordship. 32.
Has anyone been released on bail?
Only
Yes,
one, Your
Lordship.
Lordship. Only one.
One accused.
Only one. So
Yes,
is he entitled to claim parity?
Yes, Lordship.
Where is that bail order?
Uh,
How do you claim parity?
Lordship. Lordship, I have not annexed that order. If this kindly allow me to.
Yeah. So
Not at this stage, sir. Let
Okay.
all witnesses of fact be examined. Thereafter, you may apply.
and 4 people.
Lordship, kindly list
He was not,
on
Your
next
Lordship,
week,
to take the car.
Sorry, dismissed.
Withdraw
Deeply
that
obliged.
petition, Lordship. I am going to withdraw that petition, Lordship.
Very well. Dismissed as withdrawn.
Obliged, Lordship.
Deeply obliged, Your Lordship.
07.
Petitioner has joined, Mr. Siddhant,
Yes, my lords. Petitioner has joined, my lords.
and you say the investigation
We are on
is
the verge of filing charge sheet,
completion.
my lords. In all fairness, we are on the verge of filing
Lordship, I
charge
am
sheet,
for the
Lordship.
complainant in this case, Your Lordship. There were serious allegations, Your Lordship. 307, Your Lordship. He has beaten my son, Your Lordship, and taken him in custody, Your Lordship.
Is the petitioner a juvenile on the date of accident?
No, Your
Incident?
Lordship. Not, Your Lordship.
No, my lords.
Not a juvenile.
Please, my lords, I am for the petitioner.
Just wait. Have we asked you, sir? Please wait. Yes, learned counsel for the complainant.
Please, Your Lordship. Your
Right.
Lordship,
Investigation is about to be completed. What is the use of taking him into custody? Tell us at this stage.
Your Lordship, this
Because
his
he
son has.
beaten you. If he has beaten your son,
Please, Your
he has
Lordship.
beaten your son, and if it is an offense,
Please, Your
if
Lordship.
the offense is proved, he will have to serve the sentence.
But Your Lordship, 307, there was attempt to murder, Your Lordship. There are serious injuries on
Very well.
his, Your Lordship.
Allowed.
Please, Your Lordship.
The investigation is
Obliged, my lords.
concluded. the petitioner shall continue to join investigation as and when called upon to do so by the IO.
Grateful, my lord.
We have heard petitioner, state as well as complainant. Yes, item 5.
May I please, Your Lordship? My Lord, the counter of state and complaint.
State has not filed counter.
I appear for the state. 1 week time I'm praying for
Yes,
counter.
no. Has he cooperated?
Has he
But
joined investigation?
Unfortunately, I've not received the instructions as yet. And this is the first time we are appearing.
Wala seeks extension of time to file counter. Same order. We record that we record that despite service of show cause notice, none has entered appearance on behalf of the respondent number 2 complainant.
My Lord, I am for the petitioner. Your Lordship had stayed the arrest. My Lord, if Your Lordship permit me, I'll join the investigation also, my Lord.
We are saying that on the same terms, protection was granted. That protection order will continue till the next date of hearing.
I am obeying.
If they call upon you to join investigation, please do join in your own interest.
I'll do that. I'll do.
Who appears for state of Maharashtra?
My lords, in item 6, we filed our counter on Saturday, my lords. I don't think it's on record.
No,
If
it's
my
not
lords
on
could keep
record.
this, yes, my lords, if my lords could keep this on Friday so it can be brought on record.
Very well, madam, brought on record. Friday dijiye.
Grateful, my lords. Grateful.
There's also no count.
My lords, I beg to appear for the petitioners.
Who appears
My lords,
for
I beg
state
to
of
appear.
Haryana in number 7?
My lords, the state has filed a status report on.
Very well. Yes, state. What is the state's version?
Yes, my lords. We have filed our counter on 15th, my lords. And as per my lord's last order dated 16th of April, my lords had mentioned at para 4 that we need to mention in the counter affidavit whether he has joined investigation and what is the outcome. My lords, I have mentioned at para 13.
No, we don't have the affidavit, sir.
Has he cooperated? I mean, he has appeared before the investigation.
My lords, he appeared before the IO on 23rd of April, but he was evasive while joining investigation because a recovery of rupees 57 lakh has to be recovered from him, my lords. That is only my submission.
Very well. Let your affidavit come on record.
My lords, I'm praying for 2 weeks' time to file a reply to the status report, my lords.
Very well. Has been filed on 15, registry to tag with the record. Rejoinder be filed by Friday. Friday ka date dijiye. And released on 28th.
My lords, I'm praying for 2 weeks, my lords. There are some documents that I will have to produce, my lords.
All give him that.
Well,
Take up.
My lords, there is some allegation with respect to some antecedent.
Rejoinder within a week, within Friday. You did not file those documents before the High Court. Why should we allow you to file it
No,
now?
my lords, this is an order which is an allegation made by the state, my lords, status report, which speaks towards the antecedent that I have. I'll have to just produce that order and
orders you can produce and place it before the court.
my lords, I'm just seeking for 2 weeks' time.
2 weeks' time. This is very conveniently made so that you enjoy another 6 weeks of liberty during the partial working days.
Not at all, my lords.
Very well.
Any date.
The first week of June, you will come? First week
Please,
of
my
June?
lords. Please, my lords.
Yes. Counsel for the state, first week of June?
My lords, I'll appear BC, my lords. No worries. I'll be there.
मैडम ऐसा कर दीजिए, डेट ऐसा फिक्स कीजिए ताकि हमारे पास सामने फर्स्ट वीक ऑफ जून में आता है.
Grateful, my lords.
Item 8.
My lords, I am appearing for the petitioner, your lordship. My lords, there are subsequent development has been taken place. My lords, I have filed an IA number 153061 of 2026, your lordship. My lords,
what are the developments?
My lords, the offence is under section 140, 147, 48 UAP. My lords, submission is that, your lordship. My lords, I am seeking short accommodation to fix the date any
No,
non-miscellaneous.
very
Your
sorry,
lordship.
very sorry. 8 criminal cases against you. You want to
My
eliminate paramilitary people.
kindly have a my lords
No,
IN
no.
number.
An offenses of 2014 with great difficulty, the state was able to arrest
After
you.
10 years.
Please,
After
your
10 years.
lordship, kindly give me chance to my lords.
No, no,
kindly
no.
have
Very
a,
sorry.
Acha, 1 minute.
yes, your
You
lord.
are asking for NMD.
Yes, your lordship.
Notice been issued on your petition.
No, your lordship, no.
Then how can you
Then
ask
my
for
lords, I can
non-miscellaneous
argue on
date?
merit, my lords. My lords, right now I can.
We have gone through your file. You are the High Court has said you are a hardened criminal.
Yes, sir.
You have 8 antecedents. Right?
He's a
UAPB Act has
Naxalite,
been
my lord.
imposed. This is not a case where we are going
My
to
lords, kindly have a IN number
Sorry,
153066.
sorry, very sorry. You want
My lords,
you
this
want to
on
keep
my lord,
paramilitary
coordinated
people?
bench of this honorable
No,
court
no,
has
very sorry,
granted
very
bail
sorry.
to an accused
Oblige,
might
my
having
lord.
59
Very sorry,
antecedents.
sir.
Please, your lord, kindly consider your
No,
lordship.
very sorry.
No, we have
My lord,
considered.
We have
my lord,
We have considered the nature of the offense, the allegations. Just open it. Mr. Counsel, we have considered the nature of allegations against you, the gravity of the crime, the
Yes, yes.
conduct of the petitioner pre-arrest. For 10 years you were absconding, for which you could not be arrested.
My lord, kindly
Now,
give me an
after
opportunity to
2
present
years,
the
we
case.
are not going to release you on bail.
My lords, kindly give me an opportunity to produce my lords. My lords, I am humbly praying for that.
Production of documents will not help you.
My lords, my lords,
can you dispute
investigating
that
officer has not summoned or investigated.
You were arrested 10 years after the FIR? Are you?
My lords, I have produced before the court, my lords, through production warrant. Investigating officer has never sent a summon or notice.
Next case.
I'm so good.
Your Worship, I am appearing for the petitioner.
The
Your Worship,
trial is at the
despite the
verge of
repeated
completion.
order of this honorable court, trial could not be
Out of
concluded
14,
yet. Your
11 have
Worship.
been examined.
Please.
Out of 14, Your Worship, 11 have been examined. And Your Worship, even the sole eyewitness has been examined. And from the deposition of sole eyewitness,
regard to the
Your
advanced
Worship,
stage
it is
of the
evident that the earliest version of the
11
prosecution case has been suppressed. Initially, there was petitioner was not named, and Your Worship, after 1 day, on a basis of written complaint, his name was added by his political opponent. Your Worship, under that, he is completely innocent. Your Worship, he is languishing in jail since 3.5 years. Your Worship.
No,
Dismissed.
please let the trial be over.
Please.
At this stage, we are not inclined. Next.
Oblige, my lord.
Wait, please, Your Lordship. My lord, these are all offences triable by magistrate.
Arey, you are forging PMO's letter and all those things. What kind
Please
of
see this. Please see this. There are 2-3 aspects. One, these are all tribal by magistrate. Your Lordships have said if it is tribal by magistrate, it should not even
What is
reach
the
to this
allegation
court and the
against you,
lower
sir?
court should grant bail. Two, second, Miller, on the same set of facts, other 2 FIRs were lodged where the High Court, where the Sessions Court grants anticipatory bail. Second, the trial court also grants regular bail, says the FIR is belated by so many years. Here also the FIR is belated by so many years. Please have a look at those trial court orders. Please have a look at that order.
Charges have been framed.
Page number. In one case, charge is framed. The other case, charge is not yet framed. And
In
there is
this case.
a long delay of more than 1.5 years in
So
lodging
in
the
this
FIR.
case, charge has been framed or not?
There are two cases, my lord. In one case, there is a charge frame. The other, there is charge sheet file, no charge frame. And these are all tribal by magistrate.
We are seeking bail in connection with FIR number
1059. Two FIR is 940 and 1059.
Yes, now this prayer
FIR
is
number 940 of 2024. Yes.
This is in connection with 1059. In this 1059, charges have been framed or not?
1059 charges are not framed.
Then why you were saying
940 charges are framed. So there are two orders, two CR numbers where I am seeking bail. So 940 are framed, 1059 no charges are framed, charge sheet is filed. And there about 38 witnesses are to be examined.
Same.
The charge sheet shows 38 witnesses.
Cancellation of bail granted by the Honorable Allahabad High Court.
No, 68. Someone else is.
Section 137, 65, 1 and 351. That is 376. AB.
I don't know. Someone else is.
6, Lordship.
There is a cross connection, I guess.
No.
Courtmaster needs to put off that 68, item 68. Someone
68 off kariye.
Number
10.
Yes. Yes. Now, Your Lordship may please see those two orders where trial court observes that there is a long delay and therefore grants bail. Here also there is a delay or long delay. Nothing recovered from the petitioner. I will show those orders. Please have a look at 106. It starts from 105 at 106. There are two orders, my lord. Please have a look at this.
Advisor to Prime Minister.
Page 101, 105 at 106. And the second, Your Lordship would see page number 113. Where while granting anticipatory bail, the trial court says there is a long delay of 2 years in lodging the FIR. Same is the present case. Lord, please have a look at page 113, about 10 lines from the top.
Charge is very grave. You are impersonating.
Lord, please see, they say that, kindly see this, man. The application is 14 crores is paid in cash.
No, that is not.
Not a iota of material to show that from where did he get 14 crores. This is unimaginable. 14 crores paid in cash. Nothing in the entire charge sheet I have checked. Nothing, no material to show from where does he get that 14 crores. And there is a delay of two years in lodging the FIR. No explanation whatsoever in the entire FIR. And that's the reason why trial court grants bail. Sessions court grants the connected matter. One, there is a summary that's closed. In such circumstances, she is being a lady.
We will request the trial court to frame the charges soon. After charges are framed, you have the liberty to renew your prayer for.
In one case, charge is already framed. 36 witnesses to be examined. She is a lady. May I read one order? I could not carry it.
Why should one case charge be framed and other case not be framed? Must be you are delaying.
No, I am not. Just one more aspect. I would like to read your Lordship's order where the cases are triable by magistrate. In that case, your Lordships have said it need not even come to this court. May I read those two orders? If it is triable by magistrate and none of these offences, all these offences are maximum punishment is 7 years. I'll tell your Lordship 420 is the offence. 1 year, 7 months she has already spent in jail. She being a lady, 32 years old girl, lady. Please have a look at those orders. I have mailed it to the court master.
No, this is Kashmir Sandeep Pawar.
Yes, my lord. All tribal by magistrate.
No,
is 170, 420, 465. Sorry, my lord.
I think
petitioner is a lady or a gentleman?
She's a lady. She's a lady. Kashmira. Her name is Kashmira.
No, but you created a confusion. Sandeep Pawar.
No, Kashmira is her name.
Sandeep is father's name.
Sandeep is her father.
Father or
Kashmira is the petitioner before us. I'm sorry, Kashmira is the petitioner.
Kashmir Sandeep Pawar.
We also read Kashmir.
Kashmira. It's a Kashmira. Her name is Kashmira. I'm so blind. I'm so blind.
My lord, in item 11, my lord. My lord, in the same case crime number.
Right. In August.
But this case is of its own kind. I've never seen such a case.
I appear in item 12, Milos, for the petitioners.
Item 12, I want to know only one thing. What is the age of this gentleman?
Approximately 74 years, Milos.
4 years.
70 plus. Because interim protection in the meantime, it's an anticipatory bail.
Very good.
307. Yeah.
Prepare for the state in this.
Milods are granting interim Milods. I'm so sorry for
Yes,
repeating
yes.
Milods.
Yes, yes.
Deeply obliged. Deeply obliged, Milods.
13.
Milods, I appear on behalf of the state Milods in item 12. I accept
Very well.
notice.
Mr. Sharma accepts notice. File your counter.
Yes, ma'am.
Item 13.
Milods, in item number 13, Milods, I'm speaking passive Milods. I'm led by Mr. Siddharth Dave, senior advocate Milods. Milods, I'm seeking passive Milods, 13 Milods.
Mr. Prakash, number 13, please, someone else, please switch. Stop that conversation and talk to us.
Milods, in item number 13, Milods, I'm seeking pass over. I'm led by Mr. Siddharth Dave, senior advocate Milods.
Very well. Pass over.
Grateful Milods.
Who appears in item 14? Item 14. Pastor.
There's no clause for just sub
The issue here is that I was awarded a contract.
Oh, Mr. Naik, you are appearing.
Yes, but I'm appearing for the petition.
First, not on merits, first on procedure. 854
Yes, Lord.
days
What
delay.
I was telling, but in an identical matter, leave has been granted by this court and that petition is
Leave
pending.
it aside. First, hear us. Mr. Naik, please hear us. 854
Yes.
days delay. Right?
Yes. Yes.
You have not even applied for the certified copy. And your statement
Lordship.
is, if the Supreme Court requires the certified copy, I will produce it.
Yes.
Is that the law?
Yes.
Is that the law?
Lord.
So you have filed this in October.
There is a delay, but I have not.
25. Right? Your delay is still continuing. Still continuing. We'll dismiss it on the ground of delay.
No, Lordship will appreciate, my Lord. Grave prejudice will be caused to the petitioner. We have given an explanation for the delay, my Lord.
Oh,
Lordship will appreciate, my Lord. There were
for the law. You don't apply for the certified copy even after 800 days delay. Is it that easy before the Supreme Court?
Lord, we have mentioned, Lordship may kindly bear with me for a minute. We have mentioned in our application, Lord, two advocates represent.
Please come to page 248.
Yes,
Please
Lord.
come to 248.
Yes, Lord.
Paragraph C. The certified copy of the impugned judgment and order was not obtained by the petitioner due to urgency in filing the SLP. 800 days delay. And you say there is an urgency.
Lord, we have mentioned in the application, Lord, two lawyers representing the petitioner has passed away, Lord. But I am from Lord Sangli, Maharashtra. Lord, the proceedings are at Lord, in Kerala. There was flood in Kerala. Lord, two lawyers representing has passed away. That's the there is a delay, Lord. Otherwise, Lordship will appreciate, Lord.
We are not entertaining this type of petition. Sorry, dismissed.
My lords, in item 15,
yes,
I beg to appear for the petitioner, my lords. The High Court has set aside concurrent findings of facts, my lords, of the two lower courts. My lords, I am an illiterate widow, owner and resident of the suit property for the last 25 years. Two lower courts, my lords.
I'm appealing for the KV Trumera.
It's at every stage.
My lords may kindly consider.
Suit succeeded, one was dismissed before the High Court.
My lords may kindly consider granting me interim stay and protect my possession.
Are you in possession?
I am in possession, my lords. I live in the house.
Yes, just 1 minute. Where is your statement that you are in possession?
My lords, it's mentioned in my plaint. I'll just read it.
No, today, have they dispossessed you?
No, my lords, they are not My lords, they have not dispossessed me, but because they won
why
in
will
the
you
High
not
Court.
write one sentence, madam, that I am in possession and I am seeking interim relief?
My lords, I am so apologetic for the same, my lords. I am in
Things are filed
possession.
in the Supreme Court.
My lords,
You are seeking an
I
interim
really
relief without the foundation being laid.
My lords, it's there in my plane, my lords, but I apologize profusely, my lords, for this mistake.
Mr. Counsel,
I am
who
for
is
the caveator, my lord.
the respondent caveator?
My lord, I want to say three things, my lord. My lord,
Yes,
one is that
Mr.
my lord, it is
Murugan.
registered.
Dr. Murugan, are you in possession or he?
No, no. If alienation proceeds or possession is disturbed. Petition come to page 34, paragraph H.
Page 34, paragraph H, because with
Please
interim,
read
alienation proceeds or possession is disturbed. Please, my lords.
So it means you are in possession.
My lords, I am in possession.
That is why the request is that please prepare a case thoroughly.
My lords, I did. It's just that it fell from my lords and I was taken aback. I apologize.
Dr. Murugan, same day 1 lakh is returned and 20 lakh is taken.
No, my lord. But the fact is that, my lord, but here there are three facts, my lord. One is that, my lord, it is a registered mortgage deed. Then second one, my lord, son PW2
Yes,
himself attested the witness.
she is not denying her signature, but she is alleging that she was deceived by your client. And this creates suspicion in our mind that on the very day she returns the amount of 1 lakh, she will take another 20 lakh. She's an illiterate lady.
My lord, I will file my detailed counter, my lord.
Consider. Notice stay.
So grateful, my lords, and I apologize for.
Please come prepared, madam.
Foreign traveler.
No, this.
May please,
May
my lord.
please,
I appear in item 16. My lords,
May please, my lords, I'm in item 16 for the petitioners.
Mr. Sharma is for the petitioner or?
ব্যাংকে যেতে হবে কাগজ গুছিয়ে দেবে ব্যাংক থেকে করে আনতে হবে কেওয়াইসি
I'm so sorry, my lords. I'm so sorry.
Who is in 16 for the petitioner?
My lords, I'm appearing for the
কেওয়াইসি
petitioner,
করে
my
ব্যাংকে
lords.
থেকে
My lords,
16, you're challenging the review order. Where is the challenge to the parent
Yeah.
order? How can there be a challenge to a review order? If review is dismissed, order 47, rule 7 applies. This is
my lords,
in view of order 47, rule 7 CPC.
my lords, my lords, if I may be allowed to withdraw the petition.
Very well. Dismissed as withdrawn with liberty to file SLP against the parent order dated. Parent order is dated.
Parent order dated.
Give the parent order date.
Very well, my lords.
Pass over.
My lord, I am here. My lord, I am here. 17, I am here.
7.
I am
for the respondent. For the petitioner.
Yes, yes.
Yes.
I am the caveator. There are three things I like to say, my lord. In this case, permission was granted by the district inspector of school on 11/5/25 for holding the election. And the DYC appointed the observer on 15/5/2025. Election program was notified on 23/5/25. And on 26, DYC stayed the election. The High Division Bench says,
forget about the stay for the time being. Please come to para 11.
Para 11.
Para 11 and 12.
Yes.
Three reasons are given by the division bench.
That is right.
That is election not held in the premises of the institution.
Yes.
Secondly,
stay.
There is no observer who was appointed by the district inspector present.
Which is
Third is it is found that the said registration was granted to office bearers of the society and not to members. No list of members has been registered. These are the three reasons, apart from other reasons which the High Court says in para 5, we need not indicate.
Well, let me tell you, Lordship.
Let me tell you one more reason,
Lord. Let me tell you, Lordships, your Lordships, I am not in the election.
November of 25.
Really look at, I am not in the election. The question is,
Mr. Vikas Singh, please wait for your turn.
Very well.
We have indicated to Mr. Mishra, if he is successful in persuading us, then we will come back to you.
My lord, I have no, my lord, grievance with the don't recognize this election. Does the DOISC have the power to stay the election? And the division bench says yes, he has no power. Now
But
the
what kind
question.
of-
We are not on that stay, sir.
I am only saying something different. I'm saying something different. Okay, it's all right. Here, the High Court has given 3 reasons saying that your election is bad. Then the direction should have been that the registrar of the society should conduct the election as per the list. Instead of doing that, that High Court, having said that DOIC has no power, has given reasons why the election is bad. I'm not going to that reason. Please held the election by the registrar as soon as possible, because the DOIC has taken over the institution now.
Can you please come to page 217?
217, yes. That is what the single judge order.
So this order will be complied with.
No, look at, I am only saying something different. 217, your lordship have seen. Look at page 216, page 42. Please look at page 40, para 42. 216. The High Court gives, single judge says, it is also relevant circumstance the larger controversy relating to 2005 list of 111 and alleged induction of 31 members is sub judice before the division bench. I'm sorry, the division bench has dismissed this and said no list, and 3 times, my lord. That is why I request your lordship to direct the registrar in view of the observation.
High Court has already done it. High Court has already directed.
High Court has said that consider a list which is submitted by respondent number 3.
No, High Court has said hold elections as per the Societies Registration Act by following the provisions. That's all.
Well, can your lordship say that expedite the election?
Next case.
Can your lordship say expedite the election?
No. We are not here to expedite any election. Law will take its own course. Election has to be a time-bound exercise that will be taken care of in accordance with law. Yes, next matter, item 18.
Wait, please, your lordship. 4th of November 2025,
come to
your
page
lordship
17.
passed the judgment and gave certain direction.
Come to page 17. Page 17.
Yes, page 17. Yes, ma'am. Yes, my lord. There are 2 things have happened thereafter.
So therefore,
2 things have happened.
You go before the High Court and
I am not seeking review. I am seeking, my lord, clarification, my lord, because after your lordship judgment, they are not following that order. My lord, what has happened?
If any authority acts contrary to the letter and spirit of our order, now go before the relevant High Court and raise your grievance.
No, there is only one problem. There is only one problem.
After 10 years, matter is decided, and again we will reopen these matters.
No, I am not asking for doing anything, Lord. I am requesting only one thing. Then your lordship may grant me liberty. Very well, your lordship may grant me liberty to move the High Court.
We are granting that, Mr. Chaudhary.
Yes, I am so obliged, your lordships are granting.
For some time, Mr. Chaudhary, led senior counsel for the applicant, seeks permission to withdraw the miscellaneous application. He also seeks liberty to espouse his grievance before the relevant High Court. Permission granted, dismissed as withdrawn with liberty as paid.
I am so obliged.
Item 19, Foreigners Tribunal.
Yes.
Order here, huh? Item 20.
93 award, petition in 2024.
Lord, I am in 20. Let me point out 2 things. I'll just show your lordship.
Sir, when the award was passed?
Lord, 93. I was
when the petition
first
was
time in 2000.
When the petition was filed in the High Court?
Petition was filed in 24. Please see one page. Please see one page for a minute. Please see page 270 for a minute. Would your lordship see 270 for a minute? Because what I couldn't place.
We will definitely go to 70. One question in between.
Yes, ma'am.
Is it right that you did not object to the section 4 notification?
That is right, my lord. I was not aware of the proceeding. I only became aware in 2008 and I represented.
Is it? Very well said. For your satisfaction, 70.
270, my lord. 270 for a minute.
270.
270. Your lordship may see this for a minute. This is a departmental communication dated 8th of July 2011. Para 1. The land of applicant measures 4K, 4M. Church and hospital buildings were in existence at site prior to Section 4 notification. The award of the land was announced on 23rd March 93, but the award of structure was not announced. The compensation of land has not been accepted. A copy of the layout plan showing the site and structures is sent here along with, as per report of estate officer, paper possession of the land was taken on so-and-so 23rd March 93. However, physical possession of the land being religious site could not be taken. Now, my lord, please see, I started
This is in 2011.
Yes, my lord, I started representing in 2008 when I first heard.
Amount was offered to you, you have not accepted it.
No, my lord, please see page 5. Now, from the impugned order, please see page
This letter says so.
My lord, page 5, if your lordship will see, a status report was filed. Page 5, para 7, if your lordship will see, a status report is relied upon by the High Court. In the status report, they say that compensation is deposited in the court of ADJ in 2022. So they deposit compensation in the court of the ADJ after 30 years. And this 86,000 is my share out of a total compensation of 12 crores. I have been running for 60 years a dispensary and a place of worship. They couldn't find me. They could find other people to give 11 crores for 86,000. They deposited in 22. My lord, I was constantly following up since 2008. The only problem.
That shows that
Please, my lord.
Sorry, sir. Sorry.
My lord, would your lordship give me one relief, my lord? Would your lordship permit me to file?
To apply for receiving the compensation.
My lord, allow me to file a review and show these documents which were not there. My lord, 1 minute, if your lordship will bear with me. I have filed an application for additional documents.
Nothing more. You have the liberty to apply for receiving the compensation. Nothing more.
My lord, may I file review with addition and show these documents which show the chain from 2008?
Sorry, sir. Sorry.
Lord, I've been running a charitable dispensary there from 1970.
You don't respond to the notification. Sorry. Next.
My lord, the High Court proceeds on the ground that I have come after 31 years, not noting that I was following up from 2008. Can I just show 4 lines to your lordship?
We have seen it.
My lord, only.
Sorry.
My lord, can I just show? My lord,
We are
I
not
request
entertaining
only
such
4
a
lines.
scale challenge.
My lord, only 4 lines can I show?
Cannot be entertained.
My
Sorry.
lord, allow me to withdraw and file a review at least, my lord. My lord, I beseech your lordships to allow me to withdraw and file a review.
I should be allow you to withdraw and apply for review.
My lord, I'll show this finding that 31 years. I'll show that I was representing from 2008 onwards. That's all I want. Would your lordship be kind enough to permit me to withdraw and file review?
Withdrawn with liberty to apply for review.
I'm so grateful, my lord. Deeply obliged.
May it please, my lords, I beg to appear for the petitioner, my lords. Against me, an ex parte decree was passed. I have applied for setting aside that ex parte decree. The learned trial court was kind enough to allow my Order 9 Rule 13.
The interest of both parties has to be looked into by the court. It cannot be a one-way traffic.
I appreciate that.
5,000 you could not pay.
I appreciate that, my lord.
Right? So
No, my lords, I could not pay because there was a genuine mistake.
Application gets dismissed for non-prosecution. Now the court has said 50% of the decretal sum you deposit and fight out the suit.
My lords, my only grievance is.
No, it will not go to the plaintiff.
My lords,
you will get it back if the suit is dismissed. How do you suffer?
No, my lords, it will go to the plaintiff, my lords. I think, my lords, may I just respond?
Why? He has obtained a decree. You don't allow him to reap the benefit of the decree. Right? You have filed an Order 9 Rule 13. You get an order in your favor. It's only 5,000 rupees that is to be deposited. You default. Thereafter, you go before the appeal court. The appeal court has taken a very pragmatic view. It's a money decree.
My lords,
you deposit 50%.
May
then you are aggrieved.
May I respond? My lords, may I respond to that, my lords? I just have two answers. My lords. Number one, the Honorable High Court did not consider that my counsel was sick on that day. Number two, my lords, kindly see how the decree was obtained. The learned trial court, while allowing my Order 9 Rule 13, had observed that the address mentioned in the plaint was wrong. And number two, that I have a reasonable chance of success in the suit. Now, my lords, even assuming for a moment that, yes, it was dismissed for non-prosecution, my lords, a disproportionate amount of 50%, that total is amount 15 lakhs.
Disproportionate amount, he has a decree which is yet to be recalled.
My lord, see how the decree was obtained, my lord. That's why I won't.
We are not on how the decree was obtained because the matter would again go back. Today, if you deposit 50% of the decretal amount, The High Court
That
will
is
allow
15
your
lakhs.
Order 9 Rule 13. High Court will allow your Order 9 Rule 13. Your amount, instead of being retained by you, will be invested in a fixed deposit. It will not go to the decree holder. So if the decree has been obtained by fraud, or if there was no sufficient case for decreeing the suit will fail. You will get back your money.
No,
Even
my
then
lords,
you don't have to-
my only grievance is the High Court could have considered the High Court could have considered my plea for that I was sick, my lords. The High Court does not do that, my lords, and the wrong address was mentioned in the plaint itself, my lords. This is a wholly kindly consider to reduce the amount, my lords. Or
69.
22 is 20.
May I please, my lord? I am appealing for the petitioner, my lord. My lord, against the impugned order, my lord, similar SLP has been disposed of by this honorable court, my lord.
Has been disposed of. Yes, notice. Notice.
Please, my lord. My lord.
Acha, unmute 21 once again. He's still there.
my lords may kindly consider, my lords, just the amount, my lords, or it may be deposited in the court, my lords. Kindly
Mr.
consider it may be
Nagarajan, we have
reduced.
considered you don't stand to lose.
My lords, it would be deposited in the.
borrow,
I will pay that 5,000 rupees immediately.
Or get a loan from somewhere. Keep this 50% in deposit. Your money will remain with you. It will accrue interest. If you succeed in persuading the trial court, the suit will be dismissed. You will get back your money.
My lords, it would go to the plaintiff, my lords.
If you want extension of time, we can extend the time for a reason. Nothing more than that. So please don't try to argue on merits.
My lords,
we have made it clear.
I am.
How much time do you require?
My lords, may
3 weeks, we'll grant you.
My lords, may kindly grant me 2 months with an observation that it will be deposited in the court, my lords, if only for that.
3 weeks.
And it may be deposited in the court, my lords, if
the High Court. Hence, the special petition is dismissed. However, we extend the time for depositing 50% of the decretal amount till.
Or my lords, may kindly consider reducing the decretal amount, my lords. That's all, my lords. I'm so sorry.
15th of June 2026. Till such time, the decree shall be executed. In case of default, this protection shall be automatically vacated, and the decree holder entitled in law to have decree executed. Stuff. However, if the deposit is made by the petitioner, the same shall be invested in a fixed deposit of a nationalized bank on auto renewal basis, subject to further orders being made by the trial court.
Could it be 30%, my lords? I'm sorry to persist.
Don't bargain, sir.
She's a lady, my lords, and she's an old lady.
But sorry, 23.
Be pleased, Your Lordship. I'm appealing for the petitioner, Your Lordship. A common notification has been set aside in toto by the Honorable High Court, Your Lordship. My land also included in that notification, Your Lordship. And thereafter, I had approached the Honorable High Court when seeking bit of that notification.
Sir, your predecessor in interest, Mr. Haq,
Your Lordship,
he had approached the High Court. Come to page 55.
Yes, Your Lordship.
Come to page 55.
That has attained finality.
Your Lordship.
So, what is this order?
Your Lordship, Your Lordship, this order, Your Lordship, only the Honorable High Court observed that they can approach the authorities, Your Lordship. Kindly see, Your Lordship,
Your predecessor did not challenge these orders. These have attained finality, sir. Sorry.
Your Lordship, this order.
Don't dismiss.
Your Lordship, the Honorable High Court also observed, Your Lordship. Kindly see the order, Your Lordship.
We have seen, sir. We are not inclined to interfere. Dismissed. Next.
Your Lord, there is a small delay of 38 days. Your
Yes, delay we have condoned.
May it please, my lord. My lord, the cutoff date according to the notification is 1.
How many class within a class?
My lords, because the premise on the basis of which the High
Please
Court.
come to page 85.
My lord.
85.
Yes, my lord.
Page 85 is the previous order on the appeal.
Yes, my lord.
You had the appeal withdrawn with liberty to apply for a review.
Yes, my lord.
Where did you get the liberty to come back to the High Court once again with an appeal?
My lords, we filed the.
That is not there. And Upadhyay and Company, 1999 Supreme Court says, if you have not obtained that leave, your remedy is closed.
My lords, we only withdrew. My lords, we only withdrew for the High Court. Otherwise, my lords, the cutoff date is 1/4/2009 and not 1/1/2006 as the High Court.
Will
My lords, there's a delay.
condone dismissed.
My lords, the delay may be condoned.
Yes, we have condoned the delay.
My lord, I am obliged.
Item 25, notice on COD plus SLP tagged with SLP Civil 4228-42 of 2026.
Your Lordship, service to pro forma respondents 3 to 6 may be dismissed.
Very at the risk and peril of the petitioners. Service of notice on pro forma respondents 3 to 6.
Yes, Your Lordship.
Stands dispensed.
Oblige, Your Lordship.
26.
And how you somebody
Mr.
can post to
Land was acquired in 2016.
No, they have not.
A preliminary
Possession.
notification was issued. Then final notification was issued in 2017. There is no provision under the National Highway to withdraw the once it was acquired. There is no provision to withdraw the acquisition. And this is the status, my lord. They show my name in the award, but while paying the compensation, my lord, they did not pay the compensation. And they did not follow any procedure under the law to withdraw from the notification.
1 minute, Mr.
Yes.
As per
And singles is allowed my writ petition. Lordship will kindly come to page number 60 at page 65. May I read, my lord? 65 at para 7 and 8, the reasoning.
Sir, but come to page 14, page 17, paragraph 14.
17, impugned order, my lord?
Yes, page 17, paragraph 14.
Please. 17. Yes.
They say that land was by. Please read it.
Yes, my lord. In the present case, the stand of the National Highway is that by mistake, the notification under section 3D was issued, including the land of the petitioner, and therefore, when the mistake was noticed, no compensation was determined and no award was passed on possession or possession was taken. This is totally wrong. We respectfully.
That is why.
Let them return the land then.
So they're not taking it.
No, my lord. I must. They are utilizing this land for as a service road.
No,
and I could show that that report as well as the map which I have prepared, my lord.
Mala, the land has been utilized.
Yes, my land has been utilized for the service purpose, service road. I have the map. I have the photographs. Everything is available, my lord. And there is absolutely no provision under the National Highway.
Court in paragraph 14 of the impugned judgment is entirely incorrect. The land of the petitioner has been utilized for the purpose of construction of highway. Right? Rightly recorded?
For the purpose of service road.
Service road.
Service road.
Appertaining to a highway.
Yes.
In view of such submission, issue notice.
And there is a delay of 5 days, my lord.
Condoned.
Okay. Deep blue.
My lord, present petition is against the order dated 26th of November 25, whereby London High Court has upheld the order of the Sessions Court whereby my application.
Fight out the suit. Please fight out the suit.
Please.
You know, Supreme Court is in Delhi, High Court is Delhi. That doesn't mean that we will allow these sort of petitions to be entertained. This order does not affect any of your rights. If you are not liable, persuade the trial court to hold so.
My lords, item 28. May I request the matter be called out on Friday again? My lords, only request is I want to file one additional document, which I've missed filing in the main paper book. Otherwise, I can show on merits, my lords, I have a case.
Where is the contempt, sir?
My lords, that's why I requested for Friday. That's exactly the reason I started by saying that I request that the matter be taken on Friday. I'll file the addition.
Please see page 252. Please come to page 252.
Yes, my lords. That is the statement, my lords, in which
where is the recording that we are recording the undertaking of Mr. Sondhi, learned senior counsel, that the petitioners will not remove any asset.
My lords, bottom of page 252.
Statement recorded. There is no.
My lords, bottom of page 252. Please see bottom of page 252.
We are on bottom of 252, right?
Yes, my lords. The petitioners do not intend to remove any assets.
Recorded as part of the operative direction. Come to the
my lords, please see the next line. My lords, please see the next line. In consideration of these submissions, the operation of impugned order is stayed until the next day. So, my lords, the impugned order.
For contempt, there should be a specific restraint order.
Yes, my lords.
This will not amount to contempt.
My lords, may only show 190. My lords, may then permit me to withdraw it. My lords, may permit me to withdraw it.
Dismissed as withdrawn.
Much.
Lords, in 29, I appear for the petitioner. Lords. He's waiter who lost his leg. Lords, the doctor certificate certifies it to be 80%. Malas, both the courts below take it 50%, so functional will be 100% for a waiter. Malas.
No, have you been given anything for artificial limb?
Yes, Malas. I have been given, but my lords, he was a waiter for his entire life. Malas. It would not be, Malas, the same capacity that he can work with the artificial limb. Malas. And Malas, no one disputes my 80% disability. Malas. There was no occasion for both the courts below to make it 50%. Malas.
12 lakh diya hai na?
Yes, Malas, that was a 12 lakhs, Malas, which is given towards the artificial limb. Malas.
Got it, sir?
Malas, as a waiter, Malas is a family, Malas. He's a family to look after, Malas. Malas, he can't do anything. The entire right leg was amputated.
But the amount which was claimed has been given to you.
No, Malas, now that has increased, Malas, because of this artificial limb, Malas. So if Lordship compares that with the amount.
Artificial limb, 12 lakh has been given to you.
That's right, Malas. I'm not disputing that, Malas. Malas, that would not still, Malas, suffice, Malas, for the purpose, Malas. He was a waiter, Malas. He couldn't, Malas. He can't function, Malas, with an artificial limb. He can't do running around. Malas. And, Malas, no one disputed, Malas.
Always required to run.
Malas, I must indicate, Malas, this is the nature of the job, Malas, makes it so. Malas, it's a 100% functional disability.
Was he taking down orders or was he serving food?
He was serving food, Malas. No, he was a waiter, Malas. He wasn't the captain.
Somebody runs and serves food.
Yes, Malas, he was a waiter. Malas, that is a matter of the fact.
Somebody run and serve food.
No, Malas, not running in that sense, Malas. It's about.
Then he can, with artificial limb, when 12 lakh has been given, you can resume your work as a waiter.
Malas, not as a waiter, Malas, with the greatest respect, Malas. This would be, Malas. Malas, may I only say this, Malas. The 80% is what, Malas, the certificate said, Malas. There was no occasion to make it 50%.
Next matter.
Grateful, Malas. Obliged.
Item 30, my lords, I appear for the appellant. My lords, the impugned order of the NCLAT proceeds on the basis that the NCLT was acting under 221. This is, my lords, not the case, as is apparent from the order of the NCLT.
Is time bar, Mr. Solicitor?
That would be if it was an order under 221, my lords. Please just see page 59.
IBC dikhaiye 62.
This is the Companies Act, my lords.
No, this would not be regulated by 62 of IBC?
No, my lords, this is an appeal under the Companies Act. It's 423 of the Companies Act. So it is 60 plus 60 days. So we are, my lord, seeking a condonation of a delay of 38 days, which is therefore within the condonable period under 423.
I'll read it. Sorry, I was under a different impression. So we'll keep it on Friday.
No difficulty.
Right.
I'm obliged. I'm obliged.
Item 31.
May I please? Millard, you will still kindly find that the writ petition of the petitioner was allowed by the learned signature of the Honorable High Court. However, the LPA bench, Millard, at page 5 of the paper book, went contrary to the record available, Millard, on the file, and allowed the appeal of the state, Millard, intra-court appeal.
Look here, sir. You
My
are
lord.
relying on certificate of posting receipts.
My lord.
What is the worth of certificate of posting?
Millard, they were duly received.
They were not received.
Yes, that's what I'm saying. You should kindly allow me to refer to page 43 for a minute. Page 43. Page 43, Millard.
You were,
down below.
Sir, you were removed from service.
My lord.
You were removed from service following an inquiry.
My lord.
When did you file your appeal? You filed
within 1.5 months thereafter.
You have not worked. You have not worked.
You did file an appeal, but see, for 6-7 years, you did nothing.
Appeal was pending before 7 years.
You should have filed a writ petition that my appeal is not being decided.
And my humble submission
is...
is...
Be happy that the governor was kind enough to direct restatement.
Your Lordship, just allow me to refer to page 43 for a minute.
No. You have
Page 43. Page 43, Millard, down below.
You have not...
During personal hearing, Millard, third line from the bottom. 1 minute, Millard. During personal hearing, the memorialist submitted that he was not willfully absent from duty. Rather, he alleged that he was not allowed to join back after availing casually for 2 days, that is 2nd July and 3rd July 2001. In support of his claim, he submitted photocopies of these 2 letters dated so addressed by him to the DPRO, Karnal, which were sent under UPC Millard. The comments of department were sought in this regard. Director General Prison Haryana, along with the comments, has forwarded a letter of Superintendent District Jail Karnal dated so, in which he has been mentioned that as per record available in DPR office, no UPC letter was available, and as well as the same was not mentioned in any other correspondence. But the memorialist has now submitted a letter dated 7th March 2014, obtained through RTI. Same offices supply copies of those letters.
Mr. Malik, just wait. When was your appeal dismissed?
2010, Millard.
9th of February 2010.
My lord.
Right?
My lord.
When did you file the memorial before the governor?
2012, Millard.
2012, 7th of May.
My lord.
2 years, 3 months. What is the limitation?
Millard, for memorial, Millard, in fact...
There is no limitation. You can take your own time.
No, my submission is, Millard. What was factually found here?
This is the first block. Now come to 4th of July 2014. That is the governor's order.
My lord. I'm reading that very order. Right? Just for a minute. Just few lines more.
Just one.
Millard, few lines more. Only few lines more.
Just 1 minute.
My lord.
4th of July 2014 is the governor's order.
That's right, my lord.
Reinstatement without back wages.
My lord.
Correct?
My lord.
When did you file your writ petition?
In after 2 years.
2016, Millard.
Then why should you be paid? Why should you be paid?
Millard, why I should be paid? Only for that reason I'm drawing your kind attention. Only for 2 lines, Millard, further. Page 44, Millard. Page
Sir,
44.
if you want back wages,
my lord,
then we will, on your SLP, we will set aside the order of the governor and send it back for de novo consideration.
Millard, may I drive your kind attention just for Millard?
Ask for the moon.
See, you have been given benefits.
Millard, 2 lines at page 44 for a minute.
Not worked.
Millard, 2 lines at page 44, Millard. Just for a minute, Millard. It appears that it was all done with a mala fide intention to harass and harm the memorialist. That's what the observation by the highest constitutional authority of the state, Millard.
The highest constitutional authority of the state has taken a sympathetic view. Said, very well, you will get back your service, but you will not get any back wages.
But Millard, when he has been found her being allowed to remove it because of malafide intention of the department, my lord.
Malik, we are not inclined to interfere. Dismiss. 32.
My lord.
Yes, item 32.
Yes, my lord. My lord, this is enhancement petition.
Where
Your
is
lordship,
evidence that you were earning rupees 15,000?
Please, my lord. As
Where
a
is
Raj
it?
Mistri, but Honorable High Court has not considered, neither Honorable High Court nor Tribunal, my lord.
High Court has said that that evidence is not reliable.
But your lordship, if I am Raj Mistri, I am working
What
Raj
did you
Mistri.
produce as? So 15,000, we are not disagreeing with the tribunal or the High Court. Tell us one thing.
Yes, my lord.
Did you claim any amount on account of artificial limb?
Your lordship, I have not claimed this. But my lord, what's happened? This is the fault of the council, my lord. Let us, my lord, kindly consider one leg has been.
Notice on artificial limb.
Your lordship, on the part of interest also, my lord. Interest only counted 6%, lower, my lord, at least 9% interest may be counted.
No. 9% is, there is no thumb rule of 9%.
But your lordship settled in different law, your lordship, that at least interest not on 6% is lower grade, your lordship. Kindly consider 9%.
Do not disagree with the Motor Accident Claims Tribunal and the High Court that there was insufficient evidence on record to prove that the petitioner was earning rupees 15,000 per month as a mason, within bracket Raj Mistri, bracket closed. However, it is ascertained from Mr. Yadav, learned counsel for the petitioner, that despite he having suffered amputation of his right leg below the knee, he had not claimed any amount towards artificial limb and replacement thereof periodically. Limited to the above, notice be issued as to why the petitioner shall not be awarded compensation on such account.
Actually, interest may be 7% or 8%. Kindly you also consider.
Oh, interest is okay. That is the discretion. We need to leave it to the courts. Yes, item 33.
My lord, I beg to appear, my lord, in 33. My lord, I was a DCP at the relevant time. All I did was to mark the complaint to the SHO. My lord, this other side filed another complaint which was directly registered, my lord. And now this man has filed, my lord, a suit for malicious prosecution against the police officers as to, about complaints, my lord. There is nothing wrong, my lord, which has happened.
Rothki, contest the suit. It's only Order 7, Rule 11 that has been
Just have a look at the reason, my lord, a police officer to be prosecuted for marking a complaint, my lord.
Rothgi, it has been sent back for fresh consideration. No. Order 7, Rule 11 is to be considered de novo.
No, my lord, no. That's in the, sorry, my lord. Your lordships are, my lord, remembering the sanction case. In the sanction matter, sanction was refused. Then the DB said reconsider, and that your lordships have stayed. That's a different matter, my lord. Your lordships have stayed the grant of sanction or consideration of sanction.
What is remanded?
That your lordships have suspended, my lord.
Sir, please come to paragraph 3 at page 25.
Yes, it's remanded.
Consider the plaint afresh. That means Order 7, Rule 11 has to be considered afresh.
No, my lord, what will remain? Your lordship, sorry, my lord, with great respect. See paragraph 2, my lord.
We will clarify that.
300 days delay also.
Your lordship may clarify that 711 may be reheard, no problem. But not this way, my lord.
Since the High Court has made a direction with
the report is already there.
Concluding paragraph of the impugned judgment and order, which would result in revival of the petition under Order 7, Rule 11, Code of Civil Procedure, and has to be decided de novo by the trial court. We see no reason to interfere. Dismissed with the aforesaid.
Your lordship may dispose it of, my lord. My lord, it will make a difference. These are police officers facing the wrath of
After
a
the
person.
clarification that we have provided,
My lord may say disposed of is my
No.
earnest, my lord, request. These are police officers.
entertaining.
They will
Cannot
face it for the rest of their lives.
Dismissed. Next.
Milords, I'm requesting the same order in 33.1, Milords.
33.1, same order.
Please, Milords.
Same order, Your Lordship. There's a delay of a year.
Item 34.
My lord, this is a SLP against order passed beyond the relief claim form without cause of action and without jurisdiction.
Item number 34.
Yes, madam.
Could you please come to page 12?
My lord, page 12.
Page 12.
My lord.
Questions of law.
Madam.
A.
Yeah, yes, ma'am.
We are not reading it out. We are not reading it out. You read it yourself. Right?
Whether learned single
You don't
judge
have
has
to read it
acted.
loudly. You don't have to read it loudly. You first read it, what has been stated. Once you have completed reading it, we will put you a question.
Yes, my lord, I have read.
You have read it.
I
Now,
have.
the allegation that you have made, is it evident from page 6?
My lord, page 6, yes, my lord.
Is it evident from page 6?
Yes, my lord, 256 Liars Chambers, Block 1, Delhi High Court.
Oh, that's the
Page 2, the Honorable Justice, my lord, address is 256 Liars Chambers, Block 1, Delhi High Court, New Delhi. And then, my lord, Lordship will kindly come on page 8. On page 8, my lord.
Please wait.
The
This
victim.
chamber number 256 belongs to whom?
Yes. Yeah, Mr. Maninder Singh, my lord,
Please
husband
keep
of
quiet.
Honorable
Please
Justice.
keep quiet.
My lord, yes. And my lord, this is
Only for a minute. In respect of Kalkaji matters,
yes, my lord.
in a first appeal, this court has passed an order that all proceedings are stayed.
Yes. In spite of that, my lord,
Why
continuously
the Delhi High Court is proceeding in the matter?
Proceeding, my lord, proceeding, she is continuing, not passing such type of order. And this is, my lord, proceeding may be stayed, my lord. Even, my lord, one time, her ladyship was pleased to issue order of contempt in spite of order of status quo. Then
That was also stayed by this court.
yes, my lord, by your yes, my lord.
But I don't understand.
Yes, Lord.
Lord, there is a screenshot. Now 4 and 5. Now that's right. Yes, Lord. I haven't placed it on record, but there is a screenshot at least.
Item number 34, Dr. Mishra.
My lord.
Do you have the order passed by Justice Bela Trivedi and Justice Satish Sharma
Yes.
staying all proceedings?
Yes, ma'am.
Can we take it up in the second call? Can you give us the reference of the order so that we can take out a printout?
I can, just now give
Give
that
the number
order.
and the date of the ROP.
That is annexed, my lord, in 6334, and order date is 18th March 2024.
It is on record.
It is on record. This is
Where is that order?
annexed, my lord. This is annexed, my lord. Just now I'm. Sorry. That is P18, my lord.
Page number.
Page
P85. Page 285.
285.
Page
285 and
285, right?
290. 285 to 292.
There is an order of status quo.
Yes.
Yes, my lord.
There is an order of status quo.
And after that, my lord, there are two orders staying operation of respective
Where is
orders.
that? Where is that?
My lord, that is
Continuously there.
no.
Yes. P18, 19, 20, 21.
Then, my lord, next order is
This one.
Okay, order is 294.
my lord, lordship will kindly see
Yes.
page 294.
Who is your employer?
Page
My lord, the
294.
state government, my lord. I am appearing for the petition, my lord.
It starts
Here
from
I am seeking
294,
to.
and operative portion is on page 296. And the order is, my lord.
There's so many status quo orders.
And the order is, my lord, on relevant portion is on page 296.
Before 28 May. Further proceedings of FAO number 36 of 2021 pending before the High Court of Delhi at New Delhi shall remain stayed.
Much of that. Much.
Please, my lord.
Madam Trivedi, not before me.
Please, my lord. Please.
Not before a bench of which DD is a member.
You are safe today. What I wrote, I'll not tell you.
Please, my lord. I'm very aware. My apologies, my lord. I realize that.
This law, I mean.
Yes, 36.
My lords, in 36, there are two matters. I am for the landowner. Dr. Singhvi, who is waving his hand vigorously, is for the borrower.
My lords, take the 36.1 file if you lords.
Ideally, 36.1 should start, my lords.
Yeah, you do also take the file of 36.1.
But who is the borrower? 36 or 36.1?
36.1 is borrower, 36 is landowner. 36 sought to intervene in the impugned proceedings. That was not granted. So 36 has an additional hurdle to climb, which is that I should be allowed my intervention. It's my land which has been put up for auction for the first time.
I am for the caveator. I am for the auction purchaser.
Just one.
All of you, just one clarification.
Yes.
Now, DRT and DRAT concurrently set aside the sale.
In my favor.
On the ground of fraud.
Yes.
Right?
Yes.
Now, the High Court of Bombay has allowed the writ petitions filed by the secured creditor and the auction purchaser.
Lordship pleases.
And disposed of their petition with a direction to the DRT to consider the 17 application. Up to this, there is no confusion.
That's correct.
Yes,
that's correct.
Has the High Court not said anything about the sale? What happens to the sale?
Yes.
They have not said, Malus, and may I just I am the petitioner. Can I just take 2 minutes?
Yes, yes.
I've got a list of dates which is vital to show the fraud. Sent yesterday to the court master and again today. It can be handed over. Just note this, fellas.
Color scheme.
I beg your pardon?
Any colored list of dates?
Yes, it's got colors in between. In between, it's got colors, fellas, because that colors are to show the colored fraud. It's to emphasize the fraud. It will become very clear. Just give me 3 or 4 minutes. Now, fellas, I am the debtor in the sense that I am a guarantor debtor. I mortgage the property on behalf of this loan. Now, fellas, 5 dates are important in sequence, and that's enough to show the fraud. Fellas, there are in item 8, there are 6 failed attempts. Just note in item 8, 6 failed attempts, which is why the Lordship should be more suspicious when suddenly things are sold to Mr. Rodgi's client. There are 6 failed attempts. Now, in item 10, I filed 2 applications, one to injunct and one a formal amendment to bring on subsequent development. This is very important for us. I filed an injunction application prior in item 10. The date is before my lords. This is 8th May. Now look at the fraudulent action which starts on 10th and 11th. In item 12, which is 10th May, which is the red one. Just
we are not getting it.
Getting it. Or be pages hai.
List of dates. List of dates was handed over to your lordship. No, it's a list of dates. I don't know what.
We have flowchart 11th May 20.
No, Lord, flowchart is mine.
No,
I have
flowchart
the flowchart.
Please give my list of dates, please.
I have created a colored flowchart.
No,
to show how, Lord, the owner came, how the owner
Mr.
came.
Rodgi, this is not an opportunity for you to intervene. Please. I am the petitioner.
I am not intervening. I am only responding to the court's question.
No, we want Dr. Singhvi's list of dates. We have not got it.
Very sorry. The limitations of a virtual hearing.
Petitioner ka nahi aaya.
It says on top. It says on top. It says on top. Briefing note.
Sir, we don't have it, sir.
I have a suggestion. In my first matter, if you just come to page D for Delhi, those similar dates are there, which will show what the fraud is. Page D.
No, but it may not be the same chart. So, I had prepared it on that chart, but let Mr. Gopal then do it, I have no problem. Because my chart is vital to show. Can't the court master...
I have a preliminary submission. Let me place that if it meets with the lordship.
Or would your lordship do one thing, can your lordship take it on Friday? It's far too important, not to have that chart.
I don't mind, but I have a submission to make.
Land Senior Counsel, if we can just find out via media.
So I wanted to say something on that.
Will be heard afresh.
Just give me 1 minute, my lord. I wanted to say something on the via media.
One clarification. The secured asset, who is in possession of it?
I am the auction purchaser. I have a confirmed sale. I have paid everything.
No. After
decided that he should not alienate. My Mr. Rodgi is in possession.
Mr. Rodgi is in possession, you are admitting.
Yes, my lord.
And he will further alienate it, otherwise let the High Court decide.
1 minute. I have to say something else.
Can you maintain the status quo with regard to possession? Let the 17 application be decided afresh.
So, my lord is perfectly right. I have no problem. I only want to tell your lordship one thing. Justice Datta posed a question. What did the High Court do about the sale? That was the lordship's question.
Yes.
The answer is that, my lord, the DRT and DRAT set aside the sale by an interim application. In an interim application, the sale was set aside. So the High Court said, you can't set aside a sale in an interim application. That order is gone. Please argue your main case, and if you succeed, then the sale will be set aside. And that is now recorded in para 27 and para 30, my lord. So there is nothing which survives.
Either have it on Friday,
I will,
or let the status quo be maintained and the High Court decide. I haven't even opened
if you don't mind,
I haven't even
1
opened
minute,
yet.
please. Turn to para 27. At this stage, counsel for the borrower submits that the respondent intends to approach DRT to amend the application. That is, my lord, for cancellation of sale. Respondent is liberty to do so. Court has not expressed opinion on the merits of parties. All questions open, para 30. All questions open before the DRT. For on merits, my lord, because they will then argue not as an interim application. And only one more para, my lord may see, that your lordship will find paragraph 4 at page 4.
This is not the way, Manoj, with
1
respect.
minute,
He
please.
intervened because
Allow
I
me
had
to
not.
show I am doing something which will be in your favor. I will, my lord, not sell the property. That's what I'm saying.
That's all. That's all that we are saying. We are not arguing. Why is my lord arguing all
I want your lordship to record that, my lord, I have mortgaged the property. I will not, my lord, transfer or alienate the property without the leave of the court, and their main petition may be heard, in which they will re-urge, my lord, the question of fraud. That is the legal procedure.
That's all we are saying, Manoj. That's all we are saying for the time being. I would
That's
like
okay.
my
Then
lord
I'm
to
saying
decide.
something in your favor. What's the
Mr.
problem?
Rodgi, 1 minute. I wanted
Mr.
this
Rodgi,
court to
1 minute.
decide.
Yes, Dr. Singhvi, what is your response?
Well, I wanted your lordship to decide, but I think it's a fair suggestion. We don't want your lordship to waste time. Let it be decided by the High Court with a clear recordal that it will
Not
not
the
be
High Court. It is to be decided by
DRT. I'm sorry, DRT.
DRT, right.
DRAT.
Not
DRT.
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 It has to be decided. Just
It
1
is
minute.
securitization is in DRT, my lord.
Yes.
There is a Section 17 application.
Yes.
High Court has granted liberty
DRT.
to borrower to amend the Section 17 application. After the Section 17 application is amended, the DRT will hear the parties and decide the matter. Till such time the DRT decides the matter, we will record Mr. Rodgi's undertaking that he will not alienate, encumber or dispose of the property without obtaining the leave of the DRT.
Yes, correct. And my lord,
May
one
I
more
just
thing.
make one submission?
One more thing. They have already, my lord, made an application for amendment pursuant to the impugned order, which was, my lord, yesterday.
Decided together, Manoj. They've decided together.
Very well.
Manoj,
Mr. Gopal, you wanted to submit something?
One small submission. The Mr. Rodgi's client has mortgaged this property to the Punjab National Bank. The Punjab National Bank sought intervention in the High Court, saying that, look, we had no knowledge that there was this dispute pending and there was an order of the tribunals below. The problem is that now Mr. Rodgi can make whatever submission he wants. But since Punjab National Bank is not here before your lordships, making a similar statement, the difficulty is, would Punjab National Bank be in any way bound by this? Because as the mortgagee, they are entitled to take whatever steps is necessary.
Lord,
The
that
reason
is-
why I am effectively...
It's a hypothetical
That-
situation.
I'm
Mortgage
sorry,
was
Mr.
created
Rodgi,
2 years ago.
let me
Mr.
just
Gopal, one
complete.
thing.
Yes.
One thing, Mr.
Yes.
Mr. Rodgi has mortgaged the property.
Yes.
We will record that in the event Mr. Rodgi's client defaults in making payment of the installments,
Yes.
it shall be open to the Punjab National Bank to obtain the leave of the DRT and
Absolutely.
proceed under
Absolutely. No
afresh
problem.
against Mr.
Yes, that's...
Mr.
No
Rodgi.
problem. And I will not let go of this property, my lord, just for default of the bank. I took a loan to purchase the property. I will not let it go like this.
Now, just the
We have
other
heard
point
Dr.
is only
Singhvi,
this, Malak.
learned senior counsel for the petitioner in 36.1. नाम दे दीजिएगा. Mr. Gopal Shankar Narayan, learned senior counsel for the petitioner in 36, and Mr. Mukul Rodgi, learned senior counsel for the auction purchaser. Within bracket, what is your name, Mr. Rodgi?
Yes. My lord, the name is Juana. R2, my lord, Juana Sanjeev, Mrs. Juana Sanjeev Uppal.
Very well. Mrs. Joanna Sanjeev Uppal.
My lord.
R2. Right? Very well. The High Court of Bombay, by the Indian Judge Noda, has set aside concurrent findings recorded by the tribunal, so and so, and State Recovery Appellate Tribunal, so and so, whereby sale certificate issued in favor of Mrs. Joanna was set aside on the ground of fraud. While holding so, the High Court has granted liberty to the borrower and the landowner, represented by Dr. Singhvi and Mr. Shankar Narayan respectively, to amend the pending application before the DRT so-and-so under Section 17 of the Surfacing Act. All points have been kept open for the DRT to decide. Insofar as the sale is concerned, we do not find any specific observation having been made by the High Court, and it is this aspect that needs to be dealt with.
Sorry, my lord, sorry for the interruption.
Yes,
the
sir.
The High Court has set aside the orders of courts below, which had set aside the sale. So the High Court's order,
That
my lord,
means the sale revives.
Yes, sale revives.
And that
And
is what the
therefore,
High
my
Court should have addressed. It should have said something about this, that either the sale will abide by the result of the DRT,
That's correct.
that you will not alienate or encumber.
That's the problem.
It has said in para 30. It has said in para 30, my lord, that all questions are left open. It goes back.
No, that's not the point.
When the sale certificate is set aside by the DRAT,
my lord,
DRAT's order is set aside by the High Court.
Yes, my lord.
The sale certificate would revive.
Yes, my lord.
So where is the observation with regard to the sale certificate which now revives? You are not under any condition.
That's correct.
There is no condition.
You can
That is why his statement is vital. His statement is
That
vital.
is why we are saying this, sir. We are conscious that this is the limited point where the High Court should have made some of
All right, your lordship may send it
this
back.
will not affect
We
your
will re-argue
interest
it, no problem.
as you have submitted.
As your lordship pleases.
Right. We record the submission of Mr. Rodgi to the effect that Mrs. Joanna has mortgaged the property with Punjab National Bank, and that she intends to pay the installments on time. We also record Mr. Rodgi's submission till such time the DRT proceeds to decide the Section 17 application on merits de novo in terms of the order passed by the High Court. Mrs. Joanna shall not encumber, alienate, or dispose of the property without obtaining the leave of the DRT. Retaining the liberty granted by the High Court, the borrower and the landowner have filed applications for amendment which are pending consideration before the DRT. This is correct narration of facts?
That's correct.
Yes. I just want to clarify, in fairness, I, the landowner, have not filed. Mr. Singhvi, Dr. Singhvi's client has
Borrower
filed.
has filed, not landowner. Yes. Only the borrower has filed application for amendment of the
It's only
section.
his essay, my lord. No other essay. We are seeking improvement in his essay.
And circumstances, we dispose of these special leave petitions, granting liberty to the DRT to consider the application for amendment of the Section 17 application filed by the borrower in accordance with law. The DRT shall thereafter be at liberty to decide the issue finally upon granting adequate opportunity of hearing to all the parties, including the secured creditor, which, in this case is Union Bank.
And the landowner.
Till such time, the DRT decides the Section 17 application, the undertaking given by Mr. Rodgi on behalf of Mrs. Joanna shall remain operative.
Grateful.
Stop. It is also made clear that should Mrs. Joanna fail to pay the installments on time and the Punjab National Bank wishes to proceed against Mrs. Joanna, it shall be under an obligation to obtain the leave of the DRT.
Grateful.
We reiterate that all points on merits are left open for the parties to urge before the DRT for a reasoned decision by it.
Grateful.
Deeply obliged.
Grateful.
Yes, my lord, I am appearing on behalf of the petitioner.
The appeal has been
My lord, here
co-accused appeal against the same order has been dismissed, madam. So,
My lord, it has served more than 15 years
so that
in
liberty
prison,
that
and
you have,
identification is, my lord, only one thing. Identifications through TIP,
control
which is vitiated, my lord. Kindly
that
see
is
page 70.
said to be behind bars for more than 15 years, then that template order. Thirty-eight.
I appear for a petition in this matter, Miller.
Yes.
But this is a 138 proceedings.
Sir, you have been let off leniently. Huh?
Miller,
Check is of 15 lakh plus and fine
yes,
is only
Miller.
16 lakh plus. Do you
Miller,
want
what
us
has
to
happened?
as to
Miller,
why you should
he
not be
claimed,
sent to
Miller, that
prison? You want notice to be issued as to why you should not be sent to prison apart from fine? Sorry.
Miller, I wouldn't want that. Miller.
Dismissed.
Grateful.
May I please?
39.
Lord, I am appearing in 39.
Yes.
Yes, my lord.
Yes,
Lord,
Mr. Singhvi, para 14.
Yes, my lord. Para 14.
Reasons
Yes,
are given.
my lord, 44 lakhs is my annual return. And the income assessed is 25 lakhs a month, which translates to 3 crores as opposed to 44 lakhs. And my lord, this is on the basis that we are a family of Aligarh. I am having a big house in Aligarh, not in Delhi or in a metro, my lord. And my lord, we had 4 children. This marriage is of 23 years and 26 years. And 4 children, out of whom 3 I am bringing up. The 4th child is with the mother. He is a major. And my lord, this is highly excessive. I am spending a lot of money in bringing up my children. They are studying. My lord, 3 crores plus a car.
Maintenance, Mr. Singhvi. Three concurrent findings are there.
Yes.
Why should we interfere?
My lord, this is really an
Get
assessment.
it trashed out before the trial magistrate.
Pardon, my lord?
Stage.
My lord, kindly see.
No, not at this stage. Not at this stage.
My lord, just because I am bringing up my children in a good way, they are studying abroad. Therefore, to assume that, in fact, that should be a factor in my favor.
There
How
are
can I shell out
concurrent
so much money, my
findings
lord?
of fact leading to award of interim maintenance to the respondent by 3 courts. In such view of the matter, we are not inclined to interfere at this stage, leaving all points open for the petitioner to argue before the trial magistrate. The special petition stands dismissed.
Yes.
Yes. Item number 40.
Well, I am appearing for the petitioner, Malus. Well, I am protected by Honorable High Court of Gujarat for all coercive method, Malus. And I appeared before the investigation agency. This is point number 2.
Proceedings are pending before the Gujarat High Court. Why do you come with a 32 petition?
Malus, on 16th of April 2026, after no coercive action protected by the Honorable High Court, they have freezed my 6 bank accounts.
Go to the High Court,
sir. Additional bank account,
Freezing
Malus.
of accounts, we will entertain a 32. Sorry. Dismissed with liberty to approach the jurisdiction.
I'm withdrawing it, Malus. I'm withdrawing it, Malus.
Very well. Dismissed as withdrawn. Forty-one. 41, last day also nobody appeared. Huh? 41, anybody? Or a second call maker. Pass over.
My lords, 42 is also a foreigners tribunal matter.
Foreigner Tribunal 42, 43 adjourned as per letter.
44.
44.
44, my lord, Mr. Vikas Ranjan Bhattacharya leads us, my lord.
Yes.
And I am with him, my lord. I'll make the second submission. There are I think 4-5 matters.
Well, we are for the respondents.
Main matter is the.
We are for the respondents, my lord.
Lord, I appear
We are for the and also for the caveators.
Lord, I appear for the
Lord, I appear for the board.
We are for the caveators.
Mr. Gupta.
I appear in point 1, my lords, for the petitioner.
Argue for the petitioner.
I'm sorry, my lords,
very short plan that the Honorable Court did not really go by the principles of Article 14 and 16 when there is a basic allegation of institutional fraud. The learned judge records anyway, the appointees are not responsible, but that cannot be a ground to uphold the appointments which are made absolutely in violation of law. And on basis of the money, there has been a CBI investigation. CBI investigation noted huge crores of money were exchanged for the purpose of this appointment. Now, this requires consideration by this Honorable Court.
Lord, actually, we have been working for 9.5 years now. There are no allegations against any individual.
We are not passing any interim order at this stage. But today, if the allegation is this, that the candidates who have been appointed,
yes,
they do not possess essential qualifications. Yes. What will be the effect of it?
What is I mean,
this is not correct. This is pertaining to appointment of primary teachers.
Yes. Correct.
2016, the process was initiated.
Yes.
We would like to know, after the primary education board is served with notice, how many of the selected teachers had TET?
Yes.
That's at least we had.
We all of them.
We are all TET qualified. We are all TET.
If all the teachers
let the record be produced. Kindly see the advertisement.
We are all TET. If I can just
Mr.
respond.
Bandyopadhyay, if the advertisement does not say about TET qualification, that does not take away the rigors of section 23.
We all have TET.
We all have all of them. They have TET.
All of you have it. Then well and good.
Is not required. We have all after participating.
The impeachment
that was agitated.
You are not touching your appointment right now. You are not touching your appointment right now. You
Kindly come.
It has been said that
Submission by petition was after 5 years from the expiry
CBI
of
has
time.
segregated, my lord. It is not like the SSC matter where the CBI couldn't segregate.
Kindly come to page 308.
Anybody, today, if anybody is found 5 days prior to his superannuation that he did not have the essential qualification, do you mean to say that the employer has no right to terminate his service?
All of us have
Can I request kindly come to page 308?
One submission.
Is it hearing today?
Mr. Bandyopadhyay and other learned senior counsel, can you have any right of audience at the stage of issuing of notice?
No.
That is all right. But
if you don't have a right of audience, please bear with us.
Lordship is making an
Come with your counters, we will consider. We have not issued any order of stay. If we were to issue an order of stay under 148 capital A, you definitely have a right.
Only one request. Your Lordship is making one observation. One observation, which I am. Observation is not correct. Kindly,
our endeavor is to find out that our children are taught by people who are duly qualified.
Certainly.
Your lordship is not
We don't have any objection there.
No, certainly not.
If we endeavor to find out whether the teachers whose appointments were cancelled, whether they had the basic qualifications or not. It will not stand in the way.
Can I suggest?
That's the reason I am requesting your lordship kindly
An
come to
early returnable date. An
the
early
zero
returnable
eight,
date.
Yes, that is
An
important.
early returnable date.
Consider early or later on. It will come after the partial working days. It cannot come
All right,
inside of
in July or August, your lordship may keep
Milord,
telling us.
come.
Let
I
them
want to
accept
say
the
something,
notice
Milord.
period and formalities be waived.
Milord, can I
Whoever
make a
is on
short submission?
caveat, service need not be affected, dispensed with.
Yes.
But
Milord,
service
I
on
also
State of
appear
West
on
Bengal,
caveat.
service on the Primary Education Board, and whoever is
absolutely.
the public official
We are here, my lord.
have to be served.
Primary
So you are
education board
appearing?
is here, my lord. We'll accept service.
Acha, for
Mr.
whom,
Gupta is
Mr.
here.
Gupta?
The
My lord,
Primary
your lordship put
Education
a
Board, I
question, my
believe.
lord. Your lordship put a question. They are all TET trained, my lord. That is not a problem, my lord. Your lordship
Very
wishes
well,
to hear the
we'll
matter,
consider
we'll
that.
file.
First, we have to satisfy ourselves.
Your Lordship, just one other point of notice.
All
We
we
are
are
all
trained, rather this
caveators
petition
who
has
are
come
appellants
untrained.
before the High Court,
We
but
can
our
well imagine that we have to encounter this at the notice stage. What will happen after the final year?
Yes.
become easier on
Let the records be disclosed.
Repetition was not maintainable.
Everything will be disclosed.
3,000
Don't worry,
teachers,
Mr.
without
Bhattacharya.
being heard, they were
You are only
terminated.
running
we are
after
caveators who are appellants
And
before the High
kindly,
Court.
once
Your
see
Lordship, we are
paragraph
caveators who are
190 where
appellants
the
before the
CBI
High
has
Court,
said that we
but
are
the
not
appeal
this
is not
group
being
of
filed in
persons.
our matter.
Purchasing
Out of
job
44
by money.
appeal is being filed in one case.
We are all applicants before the High Court.
But
We are all
I think
appellants
once
before
your
High Court.
lordship
Your Lordship, you
issued
may be
notice,
heard.
we'll come back in July, my lord. I don't think this is really
Yes,
necessary
yes.
today.
In better
Your Lord, we will
times.
file in July. Your Lordships will hear us in July.
Very well.
Yes.
For the caveators,
even as to
But the opening statements which were made, the impression was given to the court was totally wrong.
released in the third week of August.
My lord,
Third week.
August.
We may also be allowed to file counters, my lord.
Everyone.
Caveators. Caveators.
Allowing everyone to file counter, whoever is served or whoever is appearing on caveat. Yes,
My
next.
lord.
45.
45, I beg to appear for.
Madam, is there no intra-court appeal available before the Allahabad High Court?
There is, my
Item
lords.
45.
There is, my lords. I'm sorry.
Then why have you come directly?
I am sorry, my lords. I did not even notice this. Would your lordships record my statement and permit me to?
The limitation is 60 days. 60 days. And you have already crossed 600 days. So you thought, let us take a chance before the
Lords,
Supreme.
I apologize. Your lordships may record my statement and permit me to go back, my lords. I apologize.
Madam seeks leave to withdraw this special petition with liberty to file an intra-court appeal before the High Court. Permission granted. Liberty as paid.
I'm grateful.
46.
May I seek a password, my lords? Please, my lords.
Passover. Yes. Passover 46.
So I appear for the petitioners in 47. This is the Axis Bank regarding the deposit of large amounts of money.
Mr. Gopal, you will have to deposit the money with the registry.
No, I'm the petitioner. I had to accept the money from the person who was depositing.
Right. So you are now the petitioner appellant before us.
Yes, but that money has never been given to me. So if
may not be given to you,
will deposit it,
the
we'll
direction is that you will have to refund.
Yes.
So if you want a stay of the order, we are putting you to terms.
Very well.
Getting the stay order, you will have to deposit this 3 crore 19 with the registry.
May I, Lordship, with your indulgence, Lordship, that we may be permitted to withdraw the amount subject to bank guarantee? No, 1 minute, Lordship. I'm just simply saying subject to bank guarantee.
Not at all, Mr. Kohli. You will have to decide this matter. Your money was not accepted across the counter.
Then Lordship may
How
hear
can
me
you
for a
get back
minute.
the money?
Lordship may
If
hear
you
me only
succeed,
for
you
a
will
minute.
get back the money. They are keeping it in deposit.
Lordship may hear me only for a minute, only on a limited point. We never challenged demonetization. The holding is quite correct that they unilaterally prevented me from depositing. The only mechanism I had to deposit if I was KYC, I was KYC. And therefore, they create an internal policy in derogation of the RBI's directions. So therefore, Lordship, I've been denied my opportunity.
Your money will be
It's not about,
saved, but it will not be given to you.
The appeal is admitted. Stop. For a period of a
interest-bearing
month
FIR,
from date,
Lordship.
there shall be unconditional stay of the order under appeal. Stop. If within this period of a month, the appellant deposits rupees 3,19,58,500 with the registry of this court, the order of stay shall continue till the disposal of the appeal. Should there be a default, the order shall stand vacated and it shall be open for the respondent to have the order executed before the NCDRC by instituting appropriate proceedings. Stop. Upon the deposit being made, the registry shall invest the same in a short-term interest-bearing fixed deposit account on auto-renewal basis and shall keep the account renewed until further orders to the contrary are passed by this court.
May I make one small submission?
Within 4 weeks, rejoinder, 2 weeks thereafter.
Just one small submission. We'll do this. The amount which was held by them in cash, we are unaware of what has happened. RBI has sustained our position, who is our regulator, saying during the demonetization period, if you start getting trickles of cash, 20 lakhs, 12 lakhs, 99 lakhs, we accepted the first 3. The fourth one we didn't accept because we said, where is this money coming from? Give us the source.
Lordship, I can answer that.
That is
I can
our
insist,
stand.
Lordship.
Just
now,
a minute.
Lordship, we were under protection of the Supreme Court because we had multiple rounds of litigation are there. There is no such thing about a trickle apparel. It was as many times, as much as you could deposit if you are KYC.
Were you at the final hearing?
Very well, because their cash, we don't know what happened to it. It's all old notes.
Yes.
It's not about old notes. This is about deficiency of service. It's not demonetization.
48.
Grateful.
Yes, 48. 48. Yes, solicitor.
I'm in 49, my lords. I'm sorry.
Oh, you're in 49. Then who is in 48?
No, sir.
Okay,
I
my
think
lord,
48 in this.
my apology, my lord. I'm in 48.
NTPC.
There is some confusion. My lord, kindly pardon me. But this is a neat question of law. Interpretation of section 28 of the new Land Acquisition Act. Please have, my lord, page 26, where the provision is quoted.
26.
At page 20, it starts at page 25. Well, I might read, my lord, the whole so that your lordships, I can give the background, my lord. Determination of market value of land by collector. The collector shall adopt the following criteria in assessing.
Block कर दीजिए.
And, madam, sorry.
1 minute. Yes, now you can proceed.
Yes. In assessing and determining the market value of the land, namely, A, the market value, if any, specified in the Indian Stamp Act, we are not concerned. Lord, B, we are concerned. The average sale price for similar type of land situated in the nearest village or nearest vicinity area. Or C, we are not concerned, whichever is higher, provided that the date for determination of the market value shall be the date on which the notification has been issued under section 11. Now, please see explanation, my lords. Explanation 1. The average sale price referred to in clause B shall be determined taking into account the sale deeds or the agreements to sale registered for similar type of area in the near village or near vicinity area during, please mark this, my lord, immediately preceding 3 years of the year in which such acquisition of land is proposed to be made. My lord, proposed to be made is section 8 of the Act. That is, my lord, the proposal. And, my lord, there is a purpose why, my lord, this is provided for. But for which, my lord, I rely upon the standing committee report, when this act was being enacted, Lord, they have said that once a proposal is put in public domain, people start selling their lands, and therefore that would be the right criteria to be taken into consideration. While, my Lord, if your Lordship permits, I can screen share, my Lord, that part of the report. Only one, my Lord, report is, one part is to be submitted, my Lord. Your Lordship, the court master may have to permit, my Lord, screen sharing.
So in this case, you proposed acquisition in 2016?
Yes. But
it will be a preceding 3-year period?
Yes, my Lord. The section 18 is 29th April 16. Your Lordships are right. So, my Lord, it could have been 3 years prior.
2013.
Correct. But the court has, my Lord, held that it would be from section 11 notification 3 years.
No.
That is, my Lord, page 30.
Where is that finding?
Page 30, my Lords.
No, paragraph 30.
No, page 30, para 22. My Lord, which is contrary to, my Lord, what was the intention? My Lord, this was a issue which was debated, that the moment section 8 notification comes, there are transactions. Your Lordship gets para 22? Can I read with your Lordship? This court is of the considered view that the arguments advanced by learned ASGI appearing for NTPC Limited are devoid of any merits on account of the following reasons. On the point of taking 29th April 2016, that is section 8, as cutoff date for computing the period of preceding 3 years to determine market value of the acquired land for payment of compensation. If the argument of NTPC Limited that the preceding 3 years for determination of market value is to be related to 29th April 26, when fresh application for initiation of land acquisition proceedings was made after proceeding lapsed under the old act, is accepted, it would lead to a situation that the 3 years prior to 29th April would be taken into consideration for determination of market value on the basis of issuance of notification under section 11, which is in the present case is 12th June 19. If such an argument is accepted, it would lead to a situation that any sale deed from 29th April 2016 till 11 June 2019 will not be taken into consideration to determine the market value as on the date of notification under section 11. Such is not the intention of the legislature. The legislature has clearly and in unequivocal words provided under section 26 itself that the date for determination of market value shall be the date. So when I am computing it, it will have to be today.
But sir, if you issue the 11 notification in 19,
yes,
that is the proposal for initiation of land acquisition.
No, my Lord, the proposal is section 8, my Lord, if your Lordships can see.
एक बार law दिखाइए ना. 2013 Land Acquisition Act.
2013, my Lord. And if your Lordship permits, I screen share the report of the Standing Committee.
Fair Compensation Act, 2013.
It's a right to fair compensation and transparency in land acquisition, so and so act.
Section 8.
8, my Lord. Possibly page 15 in your Lordship's copy, my Lord. We have the same. Examination of proposals for the land acquisition and social impact assessment report by appropriate government. The appropriate government shall ensure that, your Lordships can skip. 2. The appropriate government shall examine the report of the collector, if any, and the report of the expert group. Your Lordships can skip. 3. The decision of the appropriate government shall be made available in local language to the panchayat, municipality, or municipal corporation as the case may be, and the offices of the district collector, subdivisional magistrate, and the tehsil shall be published in affected areas in such manner as may be prescribed and uploaded on the website of the appropriate government, provided that where land is sought to be acquired for the purpose as specified. Lord, we are not concerned with that. That may not assist your Lordship either way. Lord, kindly see. I just read.
there has been a gap of 3 years.
Yes, my lord.
If you say that proposal is in 16, section 11 notification is in 19.
Yes, my lord.
Now, if it is more than 3 years, say, let us say 5 years, 7 years, then the entire object of this act gets frustrated.
Lord, the object we
As
will
the High
get,
Court
my
has
lord, from
correctly
the
held, within that gap period of 16 to 19, whatever sales take place would be rendered insignificant, inconsequential.
It can also be taken into consideration. Law provides prior to section 18, section 8. My lord, may I just read? My lord, I'm unable to hand over the copy.
Proposal would be for a different purpose. This proposal would not fit in.
Can I read, my lord, the report?
Such acquisition of land is proposed to be made.
Can I circulate the report of the standing committee?
So far as the authority is concerned, who is acquiring and for whom it is being acquired. But so far as the public at large, 11 is the proposal. It cannot be antedated to proposal.
11 is not the proposal. 11, please have a look at.
No, 11 is a proposal in the sense, if we go back to say
Section 4, section 4.
Section 4, 5A.
Yes.
If I give a valid objection, your proposal does not go forward if my objection is accepted. So 4 is a proposal stage.
Lord, may I just read? I am unable to hand over. Lord, this might need examination. I may succeed or fail.
No. In a proper case, you argue. But this one,
can I read? Lord, for my satisfaction, can I read?
Decimal increase. No, sir, not in this case. Not in this.
Lord, can I read, my lord, the report of the standing committee?
We are not prepared to accept that 8th proposal is the proposal referred to in section 26.
Lord, can I, my lord, read for my satisfaction? It gives a direct answer.
Read it.
My lord, I'm sorry, my lord, if your lordships can allow a screen sharing.
By the plain words of the statute. We will not go by any committee report now.
No, my lord, this is the committee report based upon which the act was made.
Maybe, but it is an external tool.
I'll just read. My lord, please allow me to.
If the language of the statute is plain and clear,
yes,
why should we adopt tools of interpretation?
May I read? My lord, your lordships may take that call, my lord, a little later. Lord, can I read?
If there is a proposal, the social impact assessment report, if it takes 2 years to come, thereafter government takes another 2 years to consider the social impact assessment report and then issues the 11 notification. Why should this sale transaction in between?
Section,
when people may not be knowing that it is under acquisition proposal, why should it be?
May I, my lord, unless your lordships allow me to read, maybe I'll not be able to, my lord, bring forward my point.
Please read.
May I read? On suggestion of the government of, this is, my lord, the Standing Committee of Parliament, discussing this particular bill, which become an act. On suggestion of the government of Madhya Pradesh regarding application of clause 11.4 of the bill that seeks to ban all kind of land transactions of the appropriate land before SIA is considered. That is, my lord, social impact assessment is conducted so as to, I'm sorry, my lord.
Yes, please continue.
No, your lordships would not get it in the file.
No, we are not.
It's not alleged.
No, I know that it's not in the file. You said so.
SIA is conducted so as to restrain mischief mongers from artificially ballooning the prices of land. The DOLR stated that a social impact assessment needs to be conducted before notification under clause 11. However, to contain, please mark this, artificial inflation of prices, a calculation of market value in clause 26, the time of period of preceding 3 years should be taken into account from, by kindly mark, the date of SIA notification. This is what, my lord, was contemplated by the standing committee. My lord, kindly allow me to, my lord, place this on record. My lord, this would apply, my lord, pan-India. My lord, kindly allow me the genesis, the very foundation on which the act came into force. They say that
if the authority takes 5 years for the issuance of the 11 notification, anything done in between will be rendered redundant.
Lord, then explanation 1 will become otiose.
No.
Explanation 1 will become otiose.
The act should have made it clear what is meant by proposal. It cannot be just referred to section 8.
No, no, that your lordships will necessarily get. My submission is
No,
from the standing committee report.
No, sorry, sir.
Well, would your lordship say question of law is kept open?
Question of law is, you want that?
Yes, my lord. In facts of this case, my lord. Because there is genuinely, my lord, it's an arguable case. Now that your lordships have dismissed, I am saying it is an arguable case, my lord.
But Mr. Solicitor, if we pass a single one-line order, that doesn't mean that the Supreme Court has upheld the order of the High Court on. It's absolutely open to you.
Lord, better not to leave it to other.
It's a single bench order. In
Lord,
some other High Court, it may have been only of a persuasive value.
Lord, better not to leave it to others to interpret your lordship's order.
We are, you know, in our judicial academy, we are deliberating on this. Let us tell you, a single judge takes enormous effort to write a judgment, 15 pages. How much time does it go behind writing a 15-page judgment? At least 2 hours in chamber. Matter comes up before a division bench. Division bench takes another 2 hours at the residential chamber to write its own judgment, affirming the single bench order. Matter comes up before the Supreme Court, and we say, not a question of law is kept open. What happens to the judicial time that is wasted there?
Lord, I may not have any answer to that. Would your lordship say in facts of the case?
Yeah. So therefore, we will have to keep the question of law open only in those cases where there is doubt evidently, palpable on the face of it.
Would your lordship say in facts of the case dismissed?
This is not such a case. So one line dismissal.
I'm not insisting for.
There is no merger. There is no merger. That judgment is open. You go in a similar case and say that it doesn't mean that the Supreme Court has affirmed the judgment of the Jharkhand High Court.
Only one. I'll not request for question of law. Would your lordship say in facts of the case?
Nothing more. We are not inclined to interfere. Dismissed.
Please, your lordship.
Obliged.
Yes, 61.
Item 49.
Now we are on 61.
May it please.
Oh, I see.
49 perhaps post notice.
Yes, the lordship will go after vacation.
I'll
tell you why not. This is that matter regarding that MSME. The latest RBI circular has to be shown to your lordship. That's why. I don't know when your lordship will take it up. Or should we, whatever.
If you are not available, we'll keep it after vacation. But
no.
Let us,
I'm available. I'm fully available. I'm not waiting.
Want to finish up the fresh matters.
All right. I'll wait.
Post notice matters.
I'll wait.
Yes, item 61.
About the petitioner and the High Court dismissed the matter because to consider the allegations on me and direction to the surrender before.
Amanullah.
Yes, my lord.
Complaint case.
My lords, exactly. So, my lords, Om Prakash versus State of Jharkhand, my lordships, as early as April of this year, has clarified that in complaint cases, a summons has to go. It is only if the summons doesn't go that there are other processes to be followed.
He is appearing before the court. Where is the question of an apprehension of arrest?
Exactly, my lords. However, my lords, in this case, what the impugned order does is that the impugned order dismisses the anticipatory, but it also says that the SP will arrest if he doesn't surrender.
That is not
proper. My lords, is, in my respectful submission, my lords, erroneous because...
What is the citation of Justice Patikala's order?
2026 SCC online SC 676.
Very well. Leave granted. The impugned judgment and order is in the teeth of the judgment and order of this court, reported in so. Accordingly, the impugned judgment and order stands set aside. We make it clear that the appellant shall appear before the trial court on each and every date fixed for trial unless exempted. Unless exemption is granted in accordance with law.
Grateful, my lords. Would my lords permit me to give my appearance in the chat box, my lords?
Before the court, no coercive steps shall be taken.
I'm grateful. My lords, could I give my appearance in the chat box, please?
Yes, yes.
I'm so grateful.
Item 62. Yes, Madam Prakash.
My lord, it appears that a land dispute has led to institution of 3 cases. One,
Notice.
I think we've lost the connection.
Notice interim. 63.
My lords, it seems, my lords, the order is, despite my lord's order, no cognizance has been taken by the National Commission to, my lords,
tomorrow, sir.
My lords, still, my lords,
I accept notice on behalf of the state in item number 62, my lord.
Yes, 62, Mr. Counsel accepts notice. File your counter. Rejoinder. Come up in the 3rd week of August.
My lords have passed an order in September. Despite that, my lords, no effective steps were taken, my lords. And my lords, this is not only in this matter, in every matter, my lords, the execution is not moving, my lords. And we are at a situation where, my lords, CC complaint takes 2 years, execution is taking 4 to 5 years now, my lords.
What can be done?
What can be done?
What can be done?
My lords, I think guidelines have to be followed. Rahul S. Shah, my lords, had laid down guidelines. But
there are guidelines given by this court. Even then, the tribunals are not being able to abide by what? How can we say that they are not trying?
My lord, because after my lord's order, even 72 did not start the section.
How many cases are there and how many courts are functioning? All these things have to be taken into consideration.
My lord, 6 hearings after my lord's order, yet my lord, no cognizance has been taken. That is after my lord passed an order in September to conclude it by March, my lord, still no cognizance was taken.
Fixed before the NCDRC tomorrow. In such view of the matter, we are not inclined.
My lord, keep it in a time bound manner, extend it by 3 more months and say they will close in 3 more months. That is, my lord, can be done.
To the petitioner to persuade the NCDRC to close the execution case as early as possible in terms of the earlier order passed by this court, as well as the order dated. Well, you have the citation of Justice Padiwala's order that all execution cases should be disposed of within 6 months.
Yeah, my lord, yes, that is Rahul S. Shah, the earlier judgment.
Just send it to the court master.
I'll send it to the court master. I'll send it to
yes. Next.
Grateful.
Item 64.
Dismiss.
Very well. Mr. Diwan, we can't hear you.
Is your lordship able to hear me?
Yes, loud and clear.
Can't have free.
No. This is one.
No,
Okay.
again disruption.
Where's your volume? Can your lordships hear me? Can your lordships hear me?
Yes, yes, we can hear you.
Where's your volume?
Yes.
Can your lordships hear me this time?
Yes, sir, we can hear you.
Yes. So, Malas, may I just make the point? I apologize that we've been having some trouble with the.
You can use this.
No, just
a minute. You can use this. No,
Again, there is a disruption. Huh?
Malas,
There is a network issue.
I think the problem may be at my end. I apologize for that. Your lordships can now hear me.
Yes, yes, yes.
Yes. May I just state the point? This is an issue which, according to us, raises an important question of law. And the issue is really the interplay between sections 9 and 9A of the Minerals Development and Regulation Act. Now, I'll just tell your lordships what has happened. And please, may I do so with reference to the impugned communication, which is at page 577, 578. Do your lordships also have the Mines and Minerals Development and Regulation Act available? We had sent it to the court master.
Yes.
Your lordships have 577, 578?
Yes, 577, we have it.
Yes. Now, this is the impugned demand which I was constrained to challenge. Now, this demand, your lordships will see, is in respect of royalty, payment of royalty, third line in the impugned communication, and also subject. Your lordship has that? Now, royalty is referable to Section 9 of the Act. And Section 9 mandates that the royalty would be liable on removal of the material or on consumption of the material. So until there is removal or consumption, there is no levy of royalty under Section 9. However, there can be a levy of dead rent. Just keep this concept of dead rent just separate under Section 9 capital A. Now, there is, in the facts and circumstances of our case, the removal started only after the consent to operate. There is a mining plan approval. The mining plan approval granted by the central government mandates that you cannot operate this mine until you have until all the environmental permissions are received. And in the facts and circumstances here, those environmental permission would be the consent to operate. So just keep that in view. I have, once the consent to operate was issued to me, been paying royalty. So there's no dispute on that at all. What the impugned demand does is that it seeks to impose royalty, demand royalty for a time before I had the consent to operate on a notional basis. Now that cannot be done because the statute contemplates that until such time as there is removal and consumption, you have to pay dead rent. And here your lordships may note that I have been paying dead rent throughout the requisite period and there is no demand for dead rent. Now, may I just, we have sent it to the court master, the sections. May I just place the sections before you? So your lordships have it because there's an interpretation issue here. Section 9, first.
Why did you take the trouble of sending the entire act in a paper book? We have the enactments with us
Okay,
in court.
we'll keep that
This is
in mind.
clear wastage of paper.
Oh, I'm so sorry. So would your lordship just take up section 9? We are concerned with 9.2.
9.2.
Your lordship has it? Royalties in respect of mining leases?
Yes.
Yes. Now I'll take you straight away to 9.2. The holder of a mining lease granted on or after the commencement of this act shall pay royalty in respect of any mineral, now mark the words, removed or consumed by him or his agent, manager, employees, contractor or sublessee from the leased area at the rate for the time being specified in the second schedule in respect of the mineral. So your lordships have seen it has to be on the mineral removed or consumed by him. Now, in my case, the consent to operate, your lordship may just note that date. The CTO was issued in my case on 26th October 2023. 26th October 2023. And I have been paying royalty at the requisite rate from 26th October 2023. Now, what is to happen before that? So there is a provision in the statute for that as well. And your lordship will find that in section 9, capital A.
Yes.
Please take up 9A. There's a separate statutory notion of dead rent. Dead rent to be paid by the lessee. The holder of a mining lease, whether granted before or after the commencement of the Mines and Minerals Development Regulations Amendment Act 72, shall, notwithstanding anything contained in the instrument of lease or any other law for the time being in force, pay to the state government every year dead rent as such as may be specified for the time being in the third schedule for all the area included in the instrument of lease. Now the proviso is important. Provided that where the holder of such mining lease becomes liable under section 9 to pay royalty for any mineral removed or consumed by him or by his agent, manager, employee, contractor or sublessee from the leased area, he shall be liable to pay, please mark the words, either such royalty or the dead rent in respect of that area, whichever is greater. Whichever is greater. So it's one or the other. Now, please have a look as to what, let me just indicate as to what the collector has done, and in our respectful submission, done erroneously. So your lordships may has seen that impugned demand. It's at page 577, 578. Please have a look at that.
Is it for a period prior to the CTO?
Yes, it's for a period prior to the CTO. So just have a look at it, please. Page 578.
CTO or no CTO,
yes,
there's a payment schedule in which says that and it says this minimum production requirement, it says that first year 0.
Correct.
You're not required to take out any mineral.
Yes.
Second year is again 0.
Yes.
And it gradually increases.
Yes.
Even if the production is 0, you are not having a CTC certificate, you are required to pay the dead rent. Because when the production is 0, there cannot be any royalty.
No, so may I just note, your lordship is absolutely correct. Absolutely correct. So that's exactly my case. My case is dead rent liability is there, and I have paid the dead rent liability. So there is no demand for dead rent. That's exactly my case.
I am liable. Not.
The impugned demand is for royalty. That's the problem.
Was that it is prior to obtaining the CTO?
Yes, your lordship will see that from the demand itself.
Where is that?
Would your lordship like to have a look at the CTO? It's at page 486. It is dated 26th October 23.
486.
Your lordship has 26th October 23.
Yes.
So this is my consent to operate.
Yes.
So your lordship has noted the date, which is most important for our purposes, 26th October 2023. Now,
right.
Please see the impugned demand at page 578. He's starting the impugned demand from 1st April 22. I'll explain to you how. 22-23, and then 23-24, and then 24-25. I have paid royalty on and after the CTO date. Now, how has he gone about it? So I have also paid dead rent for the earlier period, so there's no demand for dead rent.
Oh.
Now, the High Court has confused itself and said they followed a precedent of dead rent for the purposes of royalty when the concepts are statutorily completely distinct. Now, please have a look, if your lordships would, as to how the collector has proceeded. This is on the basis of page 309, which is the erroneous basis. Yes. May I, with your permission, before I take you to that, just show you 107, please. And then I'll take you to 309 right away. Just go to 107. 107, annex your P5. Now, this document at 107, 27th November 2019, is what allows me to proceed because it's my approval of the mining plan for my mine. Please notice this. Subject, this is from the central government. Approval of mining plan submitted by you for grant of mining lease for so-and-so limestone deposit.
Please wait, please wait.
Yes, certainly.
Then senior counsel appearing for the petitioner submits that the impugned demand notice dated 17th March 2026 claims royalty from the petitioner for a period prior to obtaining the consent to operate into bracket obtained on 26th October 2023. According to him, in terms of the provisions of Section 9, royalty can be demanded only if the mining leaseholder removes or consumes minerals, which did not happen prior to the consent to operate was issued. We record Mr. Diwan's statement that the petitioner had been paying the dead rent till such time the consent to operate was issued. Please to notice stay of the demand.
I'm grateful.
Yes, please.
Wait, please, my lords. I'm appearing for the petitioner in item number 65, my lords. Now, in this case, my lords, the order of the registration of FIR, my lords, it culminated vide the order of the learned judicial magistrate, my lord. Now, the investigation was at a nascent stage, wherein specific allegations for inducement of the complainant was made against all the accused persons, my lords. At the threshold, my lords, unfortunately, my lord, the entire FIR is quashed.
Because arbitration clause in the LLP agreement?
Yes, my lords, arbitration clause was there, but despite the arbitration clause, my lords, there was specific instances of my lords criminality involved in that, and the investigating officer.
You are giving a criminal color to a civil dispute.
My lords, may kindly see the specific allegations, my lords.
Very exhaustive. Let it be.
Lords, my contention, my lords, even the learned, the investigating officer has found instances of forgery in that, my lords.
Let it be, you please.
66.
I'm appearing for the respondent, Malus.
He wants to.
Take it. When?
After 2 weeks, notices yesterday.
Why after 2 weeks?
Malus, this has been adjourned fourth time. Fourth time adjournment has been taken.
No,
But
last and final,
final. After vacation. But this can be heard this side of the vacation, Malus. That's all.
We'll keep it on next Friday.
Very well.
After vacation.
Very well, Monday.
Very well. Yes.
Monday as last opportunity. Yes, 67.
May it please your lordship. Lord, this your lordship had this had come up on the last day when your lordship was noticing that one SLP had been dismissed against the same judgment.
Yes.
Now, then when I said it was different, your lordship said your lordship had not seen it. Now the point here is we have already been appointed as assistant teachers from March 22 to April 23. The only impediment in our appointment at that time, we are B.Ed qualified. At that time, the only impediment was the state rule said we must have 50% at graduation before getting admitted to B.Ed. That NCT clarified in 2019 saying that for those who have done B.Ed prior to 1st January 2011, that 50% in graduation will not apply. There are 3 judgments, 2 of the High Courts, 1 of your lordships. When they did not allow us to compete, we went to the High Court. High Court said, yes, I'll read that interim order, that these people have done it from before 11. They have to be allowed to compete. We were allowed to compete. We got appointed. And we have been continuing since then. Thereafter, my lord, comes Divesh Kumar's judgment on 11th August 2023, after all of us had been appointed, which said B.Ed is not a valid qualification for those who are yet to be appointed after our judgment. I will read that clarification application to your lordships. Now, the SLP which came earlier are those people who had not been appointed. And they said against the remaining vacancies, please appoint us also. Your lordship said, no, we are not going to entertain. So far as I am concerned, my High Court has not decided my controversy. High Court says because Divesh Kumar has come, your writ is dismissed. I filed a review saying Divesh Kumar has nothing to do with me. That was not my controversy. My controversy was whether I have 50% is required or not. That your lordships have decided. I am continuing now for the last 4 years. If
No,
your
no,
lordship,
what about this? What about this Kuldeep Dabral versus State of Uttarakhand?
that is the one which I am explaining. That is the one they were not appointed. They came against subsequent vacancies. We have passed on that entire SLP paper book to your lordship's moderator just now. They were never appointed. They have nothing to do with us. We have been working for the last 4 years. Now the High Court has not decided our matter at all.
Learned Senior Counsel submits that persons who had not been appointed had unsuccessfully challenged the common impugned judgment and order before this court, resulting in dismissal on so-and-so date, whereas the petitioners have been working for substantial period of time.
March 22 to April 23, we have been appointed.
March 22 to
April 2023. On different dates we have been appointed.
Till 2023, and therefore are not covered by the opposite order of this court. Issue notice. If the petitioners are in service, their service may not be disturbed without.
No, your lordship, what they have done after the High Court judgment now, they have passed these termination orders and issued them on, I'll just tell your lordships. Your lordship may kindly allow us to stay our termination, 2nd May 2020.
Mr. Patwalia, termination can never be stayed.
Then whatever order your lordship was saying, if we are in service, we shall not be terminated is fair enough. We will take that.
There is a judgment, not a judgment, but short order, Suman Dutt versus State of Haryana.
About 30 of us have been relieved, rest are working, my lord.
If anybody is working, he will be protected, but not those who have been terminated.
All right. We will come back, my lord. Let us.
It's only at the instance of one petitioner. Or how many are there?
No, there are about 50 of them, 50 of them, my lord, in different matters. 50.
Next 68.
Your Lordship, please.
How much time do you
I've requested the court master to hand over a small note.
do you require?
We require, in the application, I said we require at least 2 months' time. Would Lordship just look into the note for a minute so that I will be able to explain? Kindly look into the note, small note.
Well, you'll get 2 months' time.
Very well, sir. Very well. I also want to, in fact, just to inform your Lordship, I also want to find out if I can, because it seems to be too complex a matter. And then your Lord, just Satish Sharma told me there's only about 25, 30, but we found out there were 2,500 applications only in civil lines. So we want to look
at
it.
That is why 2 months' time. That is why 2 months' time.
No. I only want to say that I would like to take stock of and find out if I can have a solution to the problem.
That also, that's why you do it, and you are. I'm very hopeful you will find a solution for that.
Maybe it's important Lords can make an observation that having a regard to the time required, if it's possible, the solution I can push the government into thinking.
Lords, one humble submission which is very important for the city of Allahabad. Lords were pleased to order for the tabulation for 96 to 98. Lords, that will not be able to give the right situation or what exactly at the threshold or at Allahabad has happened. So, Lords, may kindly consider making it till 2006, Lords. Or because the things have been done after 98 on a very higher scale.
Then it will be a gargantuan scale that nobody can manage it.
Government policy of 92 and 98.
That's right.
Lords,
these were the two policies. So we cannot make it 2006 if there is no government policy.
Lords, till 2004, may kindly consider Lords.
No. If the policy is not there.
2004 policy.
Lords,
this is built 92 and 98.
Lords, I vote up.
Referring to the order dated 21st April 2026, learned Mr. Venkatramani, Learned Attorney General for India, seeks and is granted until 31st July to complete the exercise of submitting the status report before this court as directed. Since we are granting sufficient time, it would be desirable if the state of Uttar Pradesh in the status report to be filed indicates an acceptable solution that would lead to putting an end to the lease.
Your Lordship, please.
Relist before this bench on 12th August at 3:30 p.m.
Very good. Grateful.
Great.
Application stands disposed of. Item 70. Yes, item 70.
Lord, 70 I'd like to appear for the petitioner, Lord. Lord, this is a matter where the judgment was closed. Matter was reserved for.
What is this?
It's only clarification. Yeah.
Lord, it's not clarificatory, my lord. My lord, may just have the SLP just for a moment. Lord, may just have the application for amendment at page 99 and 100.
Very sorry.
There are three aspects. There are three aspects which are being amended, my lord.
Let the matter be decided.
Lord, there is a prayer which is being added after judgment is closed. 3 dates, my lord, the judgment is closed, and then thereafter they file the application for amendment, my lord.
We allow
3 dates, my
in
lord.
the readings at the Supreme Court level.
My lord, may just have page 93. Just for a moment, my lord, may have page 93.
Cross the tribunal's hurdle. No, sorry.
Lord,
Sorry.
there is a new prayer being added. They are recouching the entire application now. And on top of that, they are rescinding their admission that they have made before in their appeal.
Next matter. Sorry. Next matter.
Grateful.
PC Act.
May it please, my lords. Was my application for regular bail for the now in custody. There is no sanction as of date. There is no cognizance for the last 3 months, my lords, on the charge sheet that has been filed. But I'm sorry, I couldn't hear, my lords, your lordships.
Better you don't hear it.
Dismissed.
All right. Can it be? Can I renew it, my lords? After then?
No, sir. My brother has issued notice.
Normally, your lordships they don't joke, so I was taken aback, my lords, from him. Normally, my lords. Normally, I'm obliged, my lords.
Hard for a moment that we had heard by issuing notice because Mr. Dave himself was not too confident.
I'm sorry.
Taking time.
But no sanction is there.
Yes, my lord. I'm obliged, my lord. Grateful to you.
41.
Please, my lords. My lords, I apologize. I did not appear earlier. Actually, my lords, in this case, I had issued an NOC to the client in 2024 itself. Somehow the client has not engaged another advocate. There were 2 cases.
Let it go. Certified copy has not yet been applied even now. And this 1116 days delay refiling delay is not attributable to the advocate on record. So therefore, let it go as dismissed as time barred.
Please, my lords. Obliged, my lords. Again, I apologize, my lords. I was not aware this was listed.
So 46.
Lord, appear for the petitioner. My lord, this is the same matter, my lord, where the order was not uploaded. Last week we had appeared. My lord, for 2 months the order was not uploaded. The order is of March 2026 and uploaded only on in May 2026, my lord.
Right.
But, the issue in this matter is whether, my lord, when does the
Chitnis, please see para 14. It has been held in the facts and circumstances.
Yes, my lord. But if your lordship sees, my lord, para 14, my lord, the learned judge says that the time to take steps, my lord, limited. If your lordship sees the middle of the page.
Why should a litigant suffer if the DRT issues the recovery certificate late?
Lord, but that was the earlier provision was like that, Lord. I had a benefit of that. The recovery certificate issued much later, my Lord. So that when there's a debt become due, my Lord, whether it's conclusive, my Lord, it became conclusive on the first date only when the matter was adjudicated. Therefore, my Lord, time should run from that date. Lord, that issue is pending for this honorable court, my Lord. But whether the time became time started to run the first date or on the date of the recovery certificate, my Lord. So, my Lord, my submission is that it should run from the adjudication, my Lord.
Rendered its opinion in view of the.
Lord, may I just make a submission, Lord, that we are ready to pay the money, Lord. Some indulgence.
We keep the question of law open as to whether the Limitation Act or the schedule forming part of the Income Tax Act would apply in a case where
we have made a proposal, my Lord.
In relation to the period of
it's
limitation.
a dwelling house, my Lord. I'm ready to make payment, Lord. Some indulgence.
Force a debt. which has been adjudicated by the DRT.
Lord, the loophole was closed after the amendment.
No longer survives. Certificate has been issued. Now you will have to fight it.
Lord, I wanted to make payment, Lord, but now, Lord, if there was some indulgence, then I would have made some payment, Lord.
Wanted to make payment, you would have made it long before and not drag the matter to the High Court. Sorry.
Obliged.
Dismissed. Dismissed. Next. Item 60 brother ये ऑर्डर किया है.
Item number
appeal.
Yes.
By directing release of the vehicle bearing MP 06HC1353 on such terms as the district magistrate may deem fit. However, we are making an observation that since the High Court is presently seized of the appeal against the conviction,
yes,
the petitioner shall be barred from disowning the vehicle in question in course of consideration of such appeal.
My Lord, we will not decide. My Lord, only thing is that if your lordships would kindly make it time bound so far as the release is concerned, because it is lying in the police station for the last many months, my Lord.
Many years.
Many years rather. So it would have become a junk by now, I think.
Then why are you asking for it? You are digging your own grave, Mr. Mukherjee, by claiming ownership of the vehicle. Anyway.
No, ownership was determined
3 months.
when I was convicted.
Within 2 months.
Much obliged.
Within 2 months.
Within 2 months.
Much obliged.
Yes, now next. Mr. Datta prayed for time after.
Yes. Lord, can be taken in because I want to show some letters. Lord, your lordship's judgment, there are conflicting.
Not today.
Not today.
Yes. Mallards are having it on another day. Item 14.
After the partial working is over.
I see.
Because now we want to revive, the government has changed the policy and place those documents also. After
in August.
Great.
August. Can it be second week of July, my lord, if it's possible?
July 1st. August. Miscellaneous, Mr. Datta. We don't have much time. So August it will come.
Grateful.
Lord, that interim. Can I suggest 4th August? Can you on 4th August if it's possible?
Let us see. The court master will find out,
All right.
Date?
Deeply obliged.
ROP will find it.
My lord, interim order to continue in this.
Interim order to continue.
Obliged.
Item 50.
My lord, I got the counter affidavit today only in this matter. My lord.
Rejoinder 2 weeks.
I would file the rejoinder within a week, my lord. I request that if the matter is listed before vacation, my lord, because the Haryana matter has already been taken up in the Rajneesh Kumar.
If I may interject, my lord, for a moment here, my lord. My lord, his limited grievance before this honorable court was, my lord, that the letter which has been given to the Honorable High Court by way of which the advertisement was withdrawn was not provided, my lord.
No, my lord, this is not the only grievance. This is not true.
Allow me, my friend. I'm not yet finished. Just give me a minute. So, my lords are aware, my lord, there is a main matter which is coming up tomorrow, wherein those directions were issued, my lord, with regard to appointment of these positions across India, my lord. Tomorrow, my lord, it is coming as item 43. Nonetheless, my lord, his grievance before the High Court was, my lord, with regard to withdrawal of advertisement, since they applied and they appeared and written examination, etc., was done, my lord. Now, my request would be, my lord, either may, my lord, permit him, my lord, to go back to the High Court. Now, my lord, that letter is also there on record, my lord. It is annexure R3, whereby, my lord, this advertisement was withdrawn for administrative reasons, my lord. If still, my lord, my lords want to hear it, my lord, I'll assist it as and when convenient, my lord.
I hear you, and tomorrow the special educator matter will not be taken up. tomorrow I'm sitting with Justice Masi for disposing of the parted matters.
Very well.
So he'll stand over.
Very well.
Special investigator will stand over 1 week for rejoinder. The list, are you available in the first week of June?
Yes, my lord, I am.
Mr. Sangwan?
My lord, if my lords may permit me virtually, my lord, I'll assist the court, my lord.
Acha, okay.
My lord, my kids are studying in US, so I'm supposed to join.
Oblige, my lord. Oblige.
June.
Very well.
If the lordship may allow, may I mention the item number 1 passover matter?
Please wait, please wait. Please wait. 51. We call 50.
I pay for the statement.
Oh, there is that matter.
Yes, my
Yes, my lord. Though the complainant is yet to enter appearance, but I filed an affidavit, my lord, which he has sworn to and attested. I handed over, my lord. If your lordships kindly have a look at IA 154175 of 26. And at page 8 of that,
yes.
my lord, at page 8 of that affidavit, the complainant, my lord, who's R3, he says, my lord, in para 3, that I have resolved all my grievances with all the accused persons, including the petitioner in the present case. I do not wish to present complaint, FAR any further, or any other proceedings in future against any accused persons arrayed in the present FAR. Therefore, the present FAR may kindly be quashed so as to close the present case. That I am swearing this present affidavit without any fear or undue influence, and the present affidavit may kindly be treated as my unequivocal and free consent for quashing the FAR. He filed a similar affidavit in the High Court, which your lordship
Sir, can you just tell me where it is, if you don't mind? I'm sorry, I was not able to track it.
Page 8
What,
of
sir?
IA number 154175 of 26. The lordships have it.
Just give me.
The lordships have seen it as well.
We have it. Mr. Luthra, it is part of IA 11541.
Just give me a moment, Lord. I'll just find. Have you got it? Just show it. I'll just see. Where is that IES?
Mr. Giri, who is your advocate on record? Can he send it by mail to Mr.
It's okay, Lord.
Luthra's office?
Do we have this? I leave it to your lordship, Lord. If your lordship.
Sumesh Jha is there.
Mr.
I think it has already been served on Mr. Luthra's AOR.
Is our 142.
It's okay, Lord. It's okay, Lord. If your lordship is satisfied, Lord, I leave it to your lordship, Lord. I've not, because I know they filed something the High Court as per my instruction. Matters.
It's in terms of the affidavit filed before the High Court, which has already been.
I am saying something which will not harm you. As I was saying, Lord, I understand they filed the affidavit in the High Court. To that extent, I've taken instructions.
We'll exercise our 142 and
leave it.
Who are the petitioner? We have perused the affidavit filed by the respondent number 3 complainant, forming part of IA 154175 of 2026. Paragraph 2 to 4 of the said affidavit read as follows. In view of the contents of the affidavit, we invoke our power under 142 and quash.
The number of the FIR is given at para 2 of the same affidavit.
09 of 2025, referred to above, paid the petition. Accused number 3. Special petition is disposed of.
Yes. No, Lord, it's a writ petition.
Grateful to your lordship. It's an Article 32.
Article 32, yes.
Yes.
The writ petition is disposed of. We really wanted Mr. Luthra to argue on the aspect of cooperation with the investigating officer, so that we could have used it against him when he moved an application for bail. Unfortunately, we don't get that opportunity.
Lord, I must tell your lordship, in fact, I mean, now that your lordship is saying, Lord, what has happened was, and I'll give you a little background, Lord. What has happened is this issue in part, and it's a little interesting. This issue in part not is being considered in that foundation forum for professionals, Lord, and in a petition by a company called Amazon, Lord, and I'm the lawyer for Amazon. Matters pending in other bench.
Well, thank you.
But anyway,
Grateful
that's I've got the affidavit, but I've seen it also. There was some. Good.
52.
May it please, Your Lordship. The counter affidavit has been filed by the state Lords. They accept that these two matters, the two petitioners, they were not engaged in any case which was sessions triable, my Lord.
Who appears for the state of Bihar?
Lord, I'm tendering my sincere apology, my Lord. There has been a bona fide mistake, inadvertent mistake on the part of the state, my Lord. Only regarding the cases, my Lord, we have mentioned in detail, if my Lordship may kindly see, at page number 4, my Lord.
Page 4 of which?
Of the counter affidavit which we have filed in this MA, my Lord.
Counter affidavit. Page number 4. So they have antecedents.
Yes, my Lord. Regarding the antecedent, my Lordship has directed them to file a status report in the SLP, my Lord.
But first case, Chakai PS, he has been acquitted.
Yes, my Lord. We have given the detail, the entire detail regarding the current status, my Lord.
Second also acquitted.
Second also acquitted.
Third also closed.
Third closed.
Closed in National Lok Adalat, my Lord. And regarding the second applicant, my Lord, Raju Paswan, my Lord, at page number 5.
Cognizance has been taken in the first case. Second case, false. So Praveen, Dipal, and Manoj and Sanjay, these four were granted bail.
Yes, ma'am.
Now,
Praveen,
now you want A2 and A6 to be treated equally.
Yes, ma'am. A2 and A6, ma'am.
So what is the name of A2 and A6?
A2 is Belu Paswan, my lords. Will find it at page 12 of the application, which is my lord's order. It starts at page 10.
Belu Paswan.
Yes.
Yes,
Belu, and 6 is Raju.
Yes, ma'am.
An application for modification in the order dated 15 December 2025, whereby the privilege of pre-arrest bail was denied to the applicants Belu Paswan and Raju Paswan, among others, whereas four co-accused, within bracket Praveen, Dipal, Sanjay, and Manoj, were granted the benefit of such bail. Having heard learned counsel for the parties and on perusal of the counter affidavit filed by the state of Bihar, we are of the considered opinion that Belu Paswan and Raju Paswan are entitled to claim parity with Praveen, Dipal, Sanjay, and Manoj. Accordingly, in modification of the order dated so and so, we direct that they shall also be enlarged on bail in anticipation of arrest on the same terms and conditions as observed in order.
That's so good, Lord.
My lords, in item 53, I appear for the petitioner.
at the outset, I would like to make a request that the parties could be sent for mediation.
I've written mediation.
My lords, I have a preliminary objection to this. In a matrimonial proceeding, I would not ordinarily oppose mediation, but my lords, in this case, the petitioner has forged my signatures on a marriage certificate and has claimed that she is my lawfully wedded wife, initiated DV proceedings,
May I then
obtained
argue my matter,
maintenance.
my lords? May I then argue?
So therefore, my lords may hear this, and I have even mentioned it because she is.
Here, Mr. Agarwal, we would be hearing this, but not before this side of the partial working days. So in between, why don't you explore mediation if it is...
Lordship, if I may, number 2, I have filed my application for stay, Your Lordship, of the impugned order. May I just give me 2 minutes, Your Lordship? The residence that is in question, Your Lordship, is mine. The dispute is between the husband and wife, Your Lordship. The residence is mine. And as per the impugned order, post-October, I've already arranged an alternative accommodation for the lady,
If you
Your
want
Lordship.
to argue, then I'll argue it, my lords. They seem to be arguing their matter in response to
This
the...
process from my own land. It's a Lordship, even if it goes for mediation, Lordship, that property belongs to me, Your Lordship. It's a dispute between the husband and wife. I don't understand as to how she's not vacating the property even after the High Court order. I've arranged for alternative accommodation. I've complied with the High Court.
You say you have arranged an alternative accommodation?
Yes, Your Lordship. Yes, Your Lordship.
The rented premises?
Yes, Your Lordship. Just 100 meters away from the current place, Your
Answer our
Lordship.
questions first, thereafter make submission. It's a rented premises?
Yes, Your Lordship.
How much rent are you going to pay for it?
We are already paying
15,000 per month. Yes, 15,000 per month plus
Two at the same time, sir.
I'm so sorry. I'm so
You're
sorry.
not in court. You just try to appreciate that you're appearing virtually. If both of you speak at the same time, we can't hear any one of you.
Apologies.
So what is the rent?
15,000, Your Lordship.
15,000.
Of the one that we have rented out.
Very well. You don't have to keep that premises. Pay 30,000 to the daughter-in-law.
My lords, if
I'm sorry, Your Lord.
my lord.
Daughter-in-law, thereafter we'll consider.
My lords, there is a
You don't have
specific.
to allow her to stay in your house. You don't have to arrange for accommodation, but pay 30,000. We'll consider.
My lords, if I may, there are specific findings that she never resided there. We were never residing there as a couple. In fact, even in the DV proceedings, she never mentions this as ever being a shared residence. There is not a whisper of this for this property, my lords. And both the courts below have said that you may offer alternate accommodation. I offered alternate accommodation before.
If you don't want to be referred to mediation, well and good. Released after the partial working days. There shall be no stay of the
Lordship,
We are
just
not
one last.
granting any stay.
My lords had
We are
stayed.
not granting any stay. Next matter.
My lords had stayed the impugned order on the last state, my lords. My lords are continuing that.
No, the stay that they are now claiming.
My application.
Oh, my lords.
They have filed an application praying for stay that is not being granted.
All right.
My lord, 54.
My
54.
lords, a fixed date may be given in this.
Who is in 54?
My lord, 54, I appear for the petitioner on 27th October 25. Mr. Banerjee, appearing for the government, had taken time to file an affidavit. 7 months have gone by, my lord, no affidavit has come. And it relates to, my lord, payment of nursing allowance to the nursing assistants. They have paid to everyone excepting 128 persons. My friend had taken last time, he said that I'll file an affidavit.
But where is Mr. Banerjee today?
Mr. Banerjee is not here today. Well, last time also he had taken time. Before that also he had taken time. Well, I'll tell you, lordships, in brief. Pardon?
Next Monday.
This coming Monday.
Yes, yes.
Okay. Thank you.
Please inform Mr. Banerjee.
I will do that, my lord. I'll certainly.
Since Mr. Banerjee, learned additional solicitor, is not present, we adjourn hearing of this special petition for the day. So released on Monday next. Mr. Mukherjee, learned counsel for the petitioners, shall inform this order to Mr. Banerjee.
I will inform you. Yes.
Yes, next.
I appeal for the petition, Malords. We are seeking short accommodation. We have recently filed a wakalatnama and there's a bereavement in the AWA's office yesterday, Malords.
AWA is in bereavement, released after
Where for the respondents?
partial court.
Malords, listed on an NMD, Malords.
Well, let it first come after vacation. We'll consider. 56.
Please, Lord. I appear on behalf of the petitioner. The DDA has filed a counter affidavit in which they have raised an entirely new case. Your lordships in the affidavit.
Please tell me whether you were included in the list of those 120 people.
Please, my lord. Please, my lord. In
What is the
3
problem
lists
with
of the DDA. My lords, I don't know what the difficulty is. The DDA was supposed to hand over possession to me in terms of your lordship's order of the 20th of November 24, 8 weeks from then.
First time?
My lords, this is after notice for the first time, my lords.
Who appears for
Your lordships, if I may say, I moved an application for impleadment.
Who is for DDA, sir?
We are.
I appear for DDA, my lords.
So what is your problem? His name is there in the list of 120 persons.
My lord, we have regularized. We were given the list of 9 people. We have given them the letter of regularization.
No. See the order passed by this court.
My lord, we had opened the premises. We had requested the RCS to conduct the draw of lots and give us the list. They have given us a list. Subsequently, we have given the letter of possession to the 9 people.
Then I really don't understand.
Can I explain, my lord? Because we are the parties who are affected by this, my lord. In fact, your lordships in the alleged final order had specifically authorized the registrar of societies to look into anyone who has an objection. And there is an.
Where is that?
Yes, my lord. The order.
Where is that order?
Yes, find that at page 32. That relates to those who were excluded. I was included in the list of 120 members.
No, I can explain, my lord. Either the petitioner can argue it and then give me an opportunity because we were not noted.
Registrar has identified 120 members of the cooperative
Please, my lords. I'm at serial number 69, my lords, on page 81. My lords, I have page 81. I'm at serial number 69.
81.
In the list of 120 members furnished by them, by the DDA, by the registrar.
You're Lokinder Verma.
That's correct, my lords.
Lokinder Verma.
There are 2 petitioners before your lordships, Lokinder Verma, and on page 86 at serial number 109, Mr. Ajit Jairam. They were both included in the list of 120 members who were approved.
Now, please come to the learned counsel for DDA. Please come to page 31.
Yes, my lords.
Please, my lord.
Read paragraph 2.
My lord, of my affidavit?
No,
No,
the order passed by this court.
The order passed by this court on 20th November 24.
My lord, 120 members, my lord, 120. My lord, the list
the order.
given by the
You have to
RCS.
you have to comply with the order. Please read the order passed by this court. Paragraph 2. You don't have it.
My lord, I have it, my lord. I'm just not opening up my system.
Because this was you made it.
My lord, the order contemplated, my lord, giving
No, please don't give your interpretation.
First, they included in the list identified by the RCS.
My lord, they have not.
Can I explain it, my lord? Your lordship has- There is a review order also on that. Page number 117 is the review order. Review filed by the present applicant.
117.
170.
117. No case review. Review is.
And see the para 5.
I'm not the review applicant. I don't know who this gentleman is.
No, don't.
I'm not the review.
Your review has been dismissed. Nothing has been. Nothing additional has been mentioned in the review. Counsel for DDA, please come to page 31.
Page 31.
Why you are avoiding reading that page?
No, there is an order passed by
You
DD
are avoiding it.
My lord, we are not avoiding. My
No,
lord, may
please
come to
read
my
now.
affidavit, my lord.
Please read, sir.
Page
Please read
31.
page 31, paragraph 2.
My lord, it says in compliance with such order, the registrar has identified 125 members who have a rightful claim to the 125 which are available.
Yes, next then.
But we are informed that allotment of the set 121 made by petitioner DDA in favor of 120 identified members of the cooperative society upon draft lots being conducted, but that possession could not be handed over to some of the members.
Next
We direct the DDA to honor the allotment made and to ensure that those members who are not given delivery of possession allotted in their favor are delivered possession thereof. But this, DDA
This is in respect of 120 only.
120.
Please,
Malad,
Lord.
this-
Respect of 120.
This is not in the RCS list, my lord. The RCS is given as a list. Madam, may look at the affidavit, my lord. We are copying anybody's claim to possession, my lord. What will we do with those flats?
Mr.
We have a
What's the
limited
name
number
of
of flats.
the Vice Chairman?
Oh, sorry,
My lord,
What is the
Lord,
name of the Vice Chairman?
My lord, may just look at her affidavit, my
What
lord.
is the name of the Vice Chairman? Give the name of the Vice Chairman.
The commissioner may be, my lord, then.
before your
Why,
lordship
Commissioner?
pass
Let the
an
Vice
order,
Chairman come.
Can I say 2 sentences, my lord?
Oh, no, please. We are very sorry.
In a contempt petition, there cannot be any impleadment.
No,
Contempt between
no.
the court and the contender. Once
No,
we are
I fully agree, my lord.
satisfied
I fully agree, my
that
lord.
the
I
order of
fully
this
agree.
court has been breached,
I'm only trying to
you are going to
assist
deal
the
with
court.
the contender. The petitioner is only in the position of an informer. His role is over now. We
No, I
will
100% agree with your lordship. Bow down to your
Mr.
lordship, my
Mishra,
lord.
who is the gentleman who is authorized or empowered to take action in terms of our order? Who will comply with our order? Tell us his name.
My lord, the commissioner, Ellen, my lords.
Commissioner. Commissioner, Vice Chairman.
Commissioner
There
LD,
is some
my lord,
factual,
my lord,
question not been
Please,
informed to your
please
lordship. I just
mute,
want to
mute,
show that to them.
My lord, actually, I am 56.1. Mr. Sarvana Kumar is the vice chairman of DDA, my lord.
Mr. Sarvana Kumar, Vice Chairman, Delhi
Okay.
Development Authority, shall remain personally present in court on 26th May at 10:30 a.m.
Grateful. Grateful.
May I just take my lords to my affidavit, my lords?
No, we will not see the affidavit because the order passed by this court is very clear.
Explain why.
Can I assist your lordship
No,
with
not
some
required.
factual corrections?
Don't intrude, sir. Sir, ko mute kariye.
No, not
mute kariye.
one second. If your lordships
No, very
permit
sorry,
me,
very
if I
sorry.
can clarify
We are
something.
muting everybody because you are not allowing us to dictate our order.
No, I'm sorry, my lord. I will not.
Please, for as to why proceedings contempt shall not be drawn up against it for acting in willful and deliberate breach of the order dated
Page 31.
20th November 2024, passed by this court. Let him come personally and explain. Thereafter, we'll check.
Grateful minutes.
Yes, next.
I'm for the petitioner in item 57, my lords.
My lords, in item 57, I beg to appear for the respondents. We've been recently engaged and seek some time to file a reply and wakalat now, my lords.
Reply by 31st July, rejoinder by 14th August, release thereafter.
But in this, the insurance company has taken a plea that the truck was seized and was lying with the police on the date the accident took place.
My lords.
So no, so state is not a party. We would like the state also to file a reply whether whether the truck was seized by the police and it was lying in the police station or not. That's a very important problem.
We, in view of the case made out in the special petition by the petitioner, we require the petitioner to impede the state of
which state, madam?
Uttar Pradesh.
UP, my lords.
State of Uttar Pradesh to be impleaded as an additional respondent. Amended memo of parties be filed within 7 days. What you found out first.
Government shall file an affidavit stating categorically whether on the date of accident the truck was under the police custody as it was seized on account of some other accident or not.
My lords, who is to file this affidavit?
State of Madhya Pradesh. State of Madhya Pradesh. Sorry, State of Uttar Pradesh.
State of Uttar Pradesh, but the amendment be carried out in the cost title.
Very well.
Next, State of Uttar Pradesh, a party, file your amended of parties within 7 days and
We'll-
effect service with this order.
My lords.
58.
Wait, please, my lords. We have complied with the order of your lordships, my lords, which is dated 30th of April 26. Office report indicates that the service is still not complete, my lords. So your lordships may. Otherwise, we've deposited the money in compliance of the 30th April order and the 16/3/26 order.
16th March order.
Yes, my lord. 16 March required us to deposit the
75% of the enhanced amount.
Yes, we've deposited that after your lordships were pleased to extend the period, my lords. Office report indicates that we filed an affidavit to that effect.
Petitioner submits that in compliance with the order dated 16th March, 75% of the enhanced amount of compensation has since been deposited with the executing court.
Yes, my lords.
Within the extended time granted by this court. This is issue.
Yes, my lords, but service is not complete.
Very well. Since service is not complete, fresh steps may be taken for effecting service. Released after the partial work.
Lordship pleases. Oblige, my lords.
My lord, in item
Lordship.
56, my lord, 56.1 was also connected, my lord. Kindly similar order we order to pass, my lord. Contempt matter.
56
against
and
DDA.
56.1 together.
Yes. Yes, my lord.
56.2. Who is in 56.2?
So I do not know, my lord. I appear in 56.1 only.
That's a 56.
My lord has directed to come in person.
56.1 के साथ order लिखिए. Shall explain his conduct as to why, in willful breach and default of the order dated so and so, possession of the identified flats has not been made over to Lokinder Singh Verma and Dinesh Saxena.
Yes, my lord. Obliged. Very much obliged.
In item 15, my lords. In item
Yes.
in
Lordship,
59,
this matter is regarding unauthorized long absence without sanctioned leave. Lordship, it constitutes misconduct and reflects lack of devotion and duty, Lordship. We had even published in the newspaper after 4 months that the person
But you
is
lost
not...
it from all courts, all the courts.
No, Lordship. What happened, Lordship? In labor court, they had taken only the ground of quantum of punishment, Lordship, not on the facts
What was
submitted
the order
by the
of the labor
petitioner.
court?
Lordship, that they said that because they
No,
admitted
what is
fact
the
in para
final
number
outcome?
5. Yeah,
What was the
Lordship.
final order?
Lordship, they said that let him continue because
He
the
succeeded ultimately. So, and
no,
what happened in
Lordship,
the High
no,
Court?
Lordship. What quantum of punishment only he was objecting, not that it was the admitted fact that yes, he did not join. And Lordship, everything was done according to principle of natural justice. There were witnesses, there were even inquiry, everything had happened, but he did not appear in anything even after the publication in the newspaper, Lordship.
You filed your SLP with a delay of 346 days.
Lordship.
And got a condemnation on the first day without the respondent being put on notice, which is contrary to the Supreme Court rules.
Lordship, but there were grounds
Be that as it may, by a further order, we said that the parties should arrive at a settlement so that lump sum compensation can be paid and the proceedings brought to a
Lordship,
close.
may I submit?
Has there been any development on that front?
Lordship, may I submit, Lordship? Lordship, what is happening? These people, when they join, only after 2 months or 3 months, they are then absconding from the
Madam,
duty.
you are arguing on
we
merits.
have got
You are
Lordship.
arguing on merits. If
Lordship.
there is no talk of an amicable settlement,
Lordship.
we will recall that order issuing notice and call upon you to explain the delay of 346 days. If we are not satisfied, your SLP will fail only on the ground of delay.
Lordship.
So it's better, instead of arguing on merits,
Lordship.
you tell us what are the developments
Lordship.
post our order requiring lump sum payment. Has
Lordship.
any development taken place?
Lordship, I have spoken to the department, Lordship. There is
Yes.
no problem, Lordship. Whatever the court instructs us, that is okay,
Who is the
Lordship.
other side?
Lord, I am appearing for the respondent who is 87 years old. My lord, they had been contesting this case for last 32 years as the award was passed in 1994. Milords, I am 87 years old now. Milords, so
Madam
Sangeeta Kumar.
Bharadwaj,
Lordship,
Madam, ask your accounts officer
Lordship,
to go to the residence of the respondent
Lordship,
and talk to him. He is 87 years old. He may not be in a position to go to your office.
Lordship.
Your officer will go to his house,
Okay, Lordship.
find out what is an acceptable solution, come back next Monday.
Lordship may be granted at least till Thursday or Friday, Lordship.
Next Monday it will come up.
Okay, Lordship.
Accounts officer go during the weekend
Lordship.
and
Lordship.
report to us on Monday next.
Oblige, Lordship.
Counsel for the respondent,
Lordship, please.
are they complying 17B?
No, Milords, not at all.
Oh, that also they're not doing.
They are not doing it, Milords.
Lordship, it was just a fact that it is very clearly given in standard rules that even after joining
You
such
know, forget
drivers,
it. No.
Statutory ordainment that any matter is pending before the High Court or the Supreme Court,
Lordship,
you are under an obligation to pay the last wages drawn.
And I want to correct you.
Lordship.
Labor court, he succeeded. There was a direction for reinstatement. However, back wages were not given to him.
Lordship.
In High Court, again he succeeded. Your petition was dismissed.
No, Lordship,
And you
that
said
is only on the non-prosecution.
What does it mean? It has not been dismissed.
No, Lordship, it was not decided on merits, but only
Was
on
it
the
dismissed or
non-prosecution.
allowed? Only two words
No,
I'm
Lordship,
asking you.
it was dismissed, Lordship.
Why you are unnecessarily you are doing all this?
Monday next.
Okay, Lordship. I will be here, Lordship, on Monday.
While we grant one last opportunity to the petitioner to get in touch with the respondent and negotiate for an amicable settlement between the parties.
Lordship, one more request that the address may be provided because we really tried hard in last all these months
Milords, this is another way,
to approach him.
It's appropriate
To
order.
another
approach
way
him
of
even-
really not.
So far as the address where the respondent is presently residing, Madam Garg shall inform the address to Madam Bhardwaj in
Lordship.
course of tomorrow.
Oblige,
Legal aid
Lordship.
matter, Milords. It's a legal aid matter. Milords,
It's a legal-
I will certainly provide her the address. But Milords, may I just say, I am 87 years old. 94 is the award pass. 32 years they had been
Very well,
prosecuted.
Madam, try to get the address of your client,
Lordship, please.
right, and inform it to Ms. Bharadwaj.
Yes, Milords.
Let us give them one opportunity, otherwise consequences will follow.
Lordship, please. Deeply obliged, Milords.
Oblige, Lordship.
Shankar, इसका address? अभी इसका बुक कर दूंगा।
उनसे मांग लेते हैं।
Address you have to provide to me because otherwise even our letters are not reaching to him.
In item number 68, I appeared, Court Master Sir. My name, it's not going to the court.
Item mentioning item number 13. Court has in over. Item 39.
Court Master Saab,
Item number 39.
the court
Court
has
is
been
over.
dismissed or
Dismiss.
it is
Dismiss.
for the lunch?
No, dismiss. Court is discharged. Court is
But
final.
but the numbers, password numbers has not been called yet.
It's called, sir. It's called.
No,
Please
I
check
mention
the.
is twice
No,
or
no.
thrice.
Check the check the sequence. Wait a minute. मैं आपको डायरेक्ट मैसेज कर रहा हूँ सीक्वेंस इस हिसाब से हो गया है पासवर्ड
नहीं मैंने 4 बार उसको ये करा है, कॉल करा है, कॉल आउट
तो
करा है,
सर
बट मेंशन
ये
करा है।
तो अब ऑनरेबल जज ने नहीं सुना तो क्या ही बोल सकते हैं सॉरी सर
उसमें डेट क्या लगी है?
इतना नहीं पता आप कांटेक्ट टू द कोर्ट मास्टर से कर लें अभी 20 मिनट 25 मिनट के बाद
Sir, my appearance in court, item number 68, sir.
सर कांटेक्ट टू द कोर्ट मास्टर सर थैंक यू सर
जी
Please contact to the court master.
to make
Please contact to the court master, sir. Thank you.